Lord, I pray deeply. You are senior to me.
But this matter needs to be included in this tomorrow's list.
What is the matter about?
Lord, I have challenged by this of a rent control regulation which is prevailing in this island. I am protected by a judgment of the apex court. It's been for many months out of list.
Please include it. No.
My Lord, I pray your lordships kindly to mention.
Yes.
My Lord, Mr. Binnu and myself are your lordship special officers in a matter pertaining to the national highway here, which runs from Port Blair up to Diglipur. The national highway was in very bad condition last year. We were appointed as special officers and we were monitoring the situation from time to time. My Lord, last circuit also the matter came up. What has happened is that during the monsoon period, the road has been badly damaged. So right now the situation is quite bad. So in the erstwhile circuit, my Lord Justice Standon's bench had considered the matter. Certain directions were passed, certain actions were to be taken, and the matter was to appear this circuit. However, on the mentioning of the National Highway authorities, the matter went to Calcutta because they wanted certain words corrected in the order. That matter came up yesterday at 2 p.m. before my Lord Justice Standon's bench. Now, those corrections have been made. Now, in the meantime, two more developments have happened. One being that the road has deteriorated to the point where it is now near critical. The photographs and reports we are getting are indicating that vehicles are now extremely unsafe. It is not even possible. It's just mud now. And an accident is waiting to happen, number one. Number two is another learned advocate has informed me that the Indian Oil Corporation has given a letter to the administration to the effect that they cannot transport petrol and diesel in the tankers safely through the road. Because if one of those tankers goes off the road or anything happens, you will have one major problem.
There was no direction for repairs.
There was. That was my Lord Justice Standon's direction.
Yes.
The problem is that now the road, there's no road. It's just mud. So any repairs will have to await the ending of the monsoon. But in the meantime, emergency repairs to make the road motorable, this was the order Justice Standon passed. They were supposed to do it and come back in this circuit. But the problem is because of those 4 words which needed correcting, the record was transmitted to Calcutta.
So now it has come back?
No. So yesterday I have addressed Justice Standon on this. His lordship has given directions that immediately within this week, the record is to come back here and has asked me also to take up the matter here. So to that extent, when I'm mentioning the matter, if your lordships direct the matter to appear on Monday, by this week, the record will come.
We'll do that.
And the registry can take steps.
Please put the other side of notice.
No, I will do so. I will inform them. And Mr. Chakraborty is there for the administration. This is not really an adversarial situation, my lord. So,
Right, yes.
because if
NHIDCL advocate has to be present. He is based in
Mr. Sanyal is there. In fact, I made the same submission yesterday. My lord, I will do.
Next appear on Monday.
Yes, my lord. I have a second mentioning, my lord, if your lordship permits me.
Yes.
An appeal has been fixed on Monday on the ground of the learned public prosecutor, my lord. Now, the learned public prosecutor, as I see, has joined back today. My lord, can I start tomorrow or on Friday, if your lordship so permits? Because if we can start on Friday, my lord.
That is to be taken up, come back on Monday.
Great.
Yes, e-mentioning?
No, your lord.
No e-mentioning? Yes, call the list, please.
I appeal for the state, my lord.
Lord, the petitioner's wife, after marriage with the petitioners, were all through residing in Port Blair, South Andaman district. Lord, with the intervention of
There was a question of jurisdiction. And
yes, Lord, I have brought the appellate sides. Lord, would
you are appearing?
My lord, prepare for the statement. I'm awaiting receipt of case diary.
You've not received the case
Not
diary
yet
as
received.
yet?
It has to come from Paschim. That PS at Paschim, Midnapur, Kharagpur, all women police stations. Single message was sent to them. The day itself when the order was passed, my lord. But receipt of the diary is yet awaited. Without the case diary,
Without the case diary, it will be difficult.
matter cannot be
I
heard on
seek
Friday.
for
What is the offense?
498A read with 307. There is no material as such. Lordship, the entire incident, what the informant has said in the written complaint relates back to Andaman Nicobar Island. She left Port Blair of her own volition. She made a complaint to the police agency that I'm going to my parents' house. There's some discord between the petitioner.
Complaint was getting put there.
The entire thing was made in West Bengal at Kharagpur with regard to the allegation which pertains to Andaman. And before departing from this island, she informed the police agency that I'm going back to my parents' house. I have no claim. I will not take any legal action against my husband. Upon reaching there, she made this complaint which relates back to the entire incident of South Andaman at there. FIR was chalked out. The mother-in-law was also entangled. She approached the session judge. She was conferred with the anticipatory bail. Even the present petitioner had been to the session judge there. It was turned down. Now I'm before this court law.
Could you appear before the principal bench?
Now, may I draw Manoj to the chapter 18 of the appellate sites? This is pertaining to Andaman Nicobar Island. I'll just show my lord. This
Please give me
is
the rules.
chapter 18, Lordship. The police agency ought not to have registered FIR, Lordship.
Give me a minute. But there's no prayer for quashing or transferring.
No, this is another application. It's coming today. It's in the list. Post 07 application is listed today before my lord. It's coming today. It's in the list, today's list. 407.
This is with regard to cases arising in the islands, not incident.
But my lord,
There's a
based on
difference.
such incident, my lord, because my lord would see the complaint, entire incident relates back to, my lord sees the FIR once.
If you have not challenged the FIR
No, there's no,
on this
till
ground,
now it has not been, I've
I
sought
think
for
you have
transfer.
to move before the principal bench.
My lord. My lord,
Since
what
this relates to rules for cases arising in the
I
island.
understand, I am under the impression, Lordship, because the case is
Case
based on.
includes suit, appeal, application,
My lord
petition
would
and
see the rule
reference.
3, all cases including.
1A,
I got it, my lord, I've seen it.
yes.
I'm not, my lord, kindly turns to rule 3. All cases including, so I was under the
So
impression,
this is again cases,
again cases.
not incidents. You are talking about a cause of action, which is not a case.
In such a case, my lordship, let this be transmitted to the principal court, my lordship.
Yes,
My lord,
by consent
my
of the
lord.
parties,
My lord,
my lord,
my lord.
so that the technical ground is not taken
My-
care of.
my- my-
my.
The FIR has been lodged before Paschim Medinipur Police Station. Paschim Medinipur Police Station. Paragraph, by consent of the parties, the matter be placed before the principal bench of the High Court Calcutta.
Lord, registry be requested to transmit the record at once because mentioning will be made and before this,
At the line.
their lordship or determine the matter lordship so that it can be taken up at earlier basis.
That bit, my lord, I think the paper book should be filed. my lord. Completed or only the-
We can deal with the appeal on the basis of documents on record. Yes, it also, let me, that is not there, everything I have annexed,
Very well, I have no difficulty.
everything I have, paper book is not required. This is not a regular appeal.
I have
Yes.
no difficulty.
Well,
Your next senior one should.
all the matters have been waiting for you, Mr. Chakraborty.
I am really sorry, my lord.
No, no, no issues. Yes,
Lordship, the charge against the delinquent is that he has molested a girl child and she has lodged a complaint before the police authorities. And on the basis of that, the disciplinary proceeding was contemplated and it was initiated. Memorandum of charges was issued. He replied to that.
Yesterday, I have substantially argued the matter, but a plea was taken that since the senior counsel was not there, I can recapture the point in its presence. Now, before the tribunal, approach was made for grant of a compassionate appointment. Now, the trial court, I'll just show that order, held that my case was considered by an expert body screening committee, and 3 times it was turned down. That's the first ground assigned by the trial court, tribunal. Secondly, the learned tribunal held, my lord, that I have not expressed my willingness which they have sought for, mainly on these 2 counts. My lord, the rules, which is because I cannot argue this issue with the touchstone of Article 14 and 16. Compassionate ground, lordship, the persons are at the mercy of employer. One thing, lordship, I can demonstrate, lordship, the relevant rules, whether the conditions have been fulfilled or not. My lord, I'll just show their papers which do form part of the reply before the tribunal, which starts at page 47. It's a part of this application.
Yes, the reply.
Reply. Now kindly turns to page 92, running page 92, internal page 47, running page 92. Below.
Yes.
Now I would find serial number 60. My name has been figured out, Sanjay Bahadur.
Yes.
This was the name proposed, and what was the finding? I'll just show that. My lords, kindly turns to page, just one second. 104, my lord. As against serial number 60. So the name of the petitioner has not been recorded, but his mother's name has been recorded as Vijay Lakshmi.
Yes.
Not just read these 3 lines. Srimati Vijay Lakshmi, wife of Sri late Kishan Bahadur, has submitted an application for appointment of her sons on compassionate ground. He possesses the qualification up to 12th standard and his age is 26 years. Earlier, her case was rejected by the committee. Srimati Vijay Lakshmi is getting family pension and her family is residing in a house constructed by late Kishan Bahadur in the landed property of Kishan Bahadur's grandmother. There is no immediate economic distress warranting appointment on compassionate ground as per the provisions of this is some reference with regard to Government of India dated 5/5/2003. Hence, the committee does not recommend the case of Srimati Vijay Lakshmi for appointment on compassionate ground. Now, this reasoning is absurd. I would say, why not? The compassionate appointment is always sought when a government servant dies during the service tenure. Once it is done, that is occurred, this pension would be released. But compassionate ground is not on that footing, Lord. Now, the very object of the compassionate rule would be frustrated because every government servant who dies, who's paid with whose dependent members are paid with the pension, are entitled to get compassionate amendment, provided the rules has been fulfilled. So this reasoning is no reasoning in the eye of law. Secondly, my lord, I'll just show one more thing. The office memorandum, my lord. Page 71, my lord. Page 71, argument has been advanced to this document. It's a OM office memorandum dated 16 January 2013, my lord.
Yes.
No, nowhere under these rules, there is any cutoff date prescribed that beyond 3 times one cannot approach before the employer for compassionate ground. Because this is one of the ground assigned by the tribunal that beyond 3 times one cannot approach the employer for compassionate ground. Nowhere under these rules. And what this point was even not pleaded in the reply. The tribunal gone beyond lordship the pleadings. This was not asserted. There was no argument made. But the learned tribunal, I'll just show my lord the penultimate paragraph at page 7 of the impugned judgment. It's serial number 7. I'm just placing for the court, my lord. It emerges from the record that the father of the applicant, that is deceased employer, had expired on 8/4/2014, and thereafter, as noted herein above,
And
on
what
this
page?
page impugned order, Lordship, running page 7. I have not paginated the impugned order, Lordship, certified 1. Not kindly turns last but one page. Yes, last but one page, page 7. Lord. At the top, Lordship, serial number 7. Page 7.
Yes,
Lord would find at the top, Lordship. It emerges from the record that the father of the applicant, that is deceased employed, expired on 8/4/2014, and thereafter, as noted herein above, undisputedly the case of the applicant for grant of compassionate appointment was considered by the competent authority more than 3 times. The screening committee did not find him fit for recommendation compared to the other claimants in the respective years. Therefore, it is not correct on the part of the applicant to allege that his case was not considered at all by the respondents. Further, it can be seen that the applicant has not placed any material proof on record with regard to his claim that he has submitted his application willingness to the respondent to work as home guard volunteers, as was offered to him with a order dated 1/11/2014 and 7/12/2014. Now, the very conduct of the petitioner and his mother, way back in the 2014, she made an application that ipso facto suffice that, Lordship, she promptly approached the authorities. And what else is required, Lordship? Even the authorities will not. I'll just show my just 2 papers in the, which is the part of the original application. Not, it's page 41, running page 41. Internal page 21 of the original application.
yes,
Lord would find,
the memo,
yes, memo dated 1st November 2014.
yes,
My representation is dated 21/7/2014. My approach was a prompt one. Not the judgments of the Supreme Court, and even our High Court says in such a case, approach has to be made at the first instance, Lordship. There should not be any delay. All those judgments are on point of delay. If I have made approach way back in the year 2014, my lord, and the authority have clearly held that I can be given as home guard volunteers. But what is the requirement of asking my willingness? Already I have put in my willingness before the authorities. What else is required? Not kindly turns to page 44.
yes, yes,
So, Lordship, the finding of the tribunal is based on no material, based on relevant consideration was not made. Now, I could find from the screening committee documents that they said that there's no vacancy although as of now. Now, this judgment I would just place. These are my 2 points of argument, and this judgment will not kindly consider it. I'm just placing it. This is reported in 1989, volume 4, Supreme Court cases 468. In the case of Sushma Goshan and others versus Union of India and others, paragraph is 9. 9 more. I'll just place paragraph 9 more. We consider that it must be unequivocally that in all the claims for appointment on compassionate ground, there should not be any delay in appointment. The purpose for providing appointment on compassionate ground is to mitigate the hardship due to the death of the bread earner in the family. Such appointment should therefore be provided immediately to redeem the family in distress. It is improper to keep such case pending for years. If there is no suitable post for appointment, supernumerary post should be created to accommodate the applicant. I've seen somewhere, Lordship, the screening committee held that there is no post available. So I would pray, Lordship, this case deserves some consideration, Lordship, and the tribunal order has to go, Lordship. That's my fear.
yes,
First submission, I want to see the
Reasons which are given. Firstly, my lords may have page 104 is the page number on top and 59 is the page number. Which is the correction?
104,
Top, 10. Random page 10.
104,
yes,
serial number 60. Srimati Vijay Lakshmi, wife of late Kishan Bahadur. This is from the screening committee's minutes. Srimati Vijay Lakshmi, wife of late Kishan Bahadur, had submitted an application for appointment of a son on compassionate grounds. He possesses the qualification of 12th standard and his age is 26. Earlier, her case was rejected by the committee. Srimati Vijay Lakshmi is getting family pension. Family is residing in a house constructed by late Kishan Bahadur in the landed property of Kishan Bahadur's grandmother. There is no immediate economic distress warranting appointment on compassionate ground as per provisions of GOI office memorandum dated such and such. Hence, the committee does not recommend the case of Srimati Vijay Lakshmi for appointment on compassionate ground. Now, my lords, may next have page number. I'll come to the statutory provision also. Page number 112. 112, my lords, may again have
serial number 19. This is again minutes of the
Yes.
screening committee. This is second minutes. Srimati Vijay Lakshmi has submitted application for appointment of a son on compassionate ground. The son, Shri Sanjay, possesses qualification for 12th standard and his age is 28 years. Vijay Lakshmi is getting family pension. Family is residing in their own constructed house is Nayagaon. Earlier, a case was rejected. Recommendation of the committee: no immediate economic distress warranting appointment on compassionate ground as per the provisions of Government of India dated 16/1/2013. Hence, the case of appointment is not recommended. Now, my lords may have after this page number 71. So they have taken this decision in terms of government's memorandum. Now, my lords may have the government memorandum. It begins at page 71 and my lord may straight away come to page 75. Determination oblique
Now,
availability of
have you mentioned the amount of family pension received by the widow? Have you recorded anywhere? Has the authority recorded anywhere? The amount of family pension received by the widow?
this page 59 and 60. (59) and 60, my lord, it's mentioned the. It has been enhanced since the litigation. As per the, this is as of 2014. Now in 2020 it was revised further. And now it is the family pension is 20,550. The enhanced family pension.
Is it on record?
No, this is as of 2014. Yes, it is there, page 60.
60?
Yes, ma'am. Page 60. Annexure A by 3.
Yes.
Now, my lords, if your lordship has the office memorandum, page 75, paragraph 7, determination availability of vacancies, appointment on compassionate grounds should be made only on regular basis, and that too only if regular vacancies meant for the purpose are available. Then, my lords, of course, the paragraph B is more in procedural, B, C, D. Now, my lords, we have paragraph E at page 76. The committee constituted for considering a request for appointment on compassionate ground should limit its recommendation to appointment of compassionate ground only in a really deserving case, and only if vacancy meant for appointment on compassionate grounds will be available within a year. Then, my lords, will see that there is also a provision for belated request, which is at page 77, para 9. It says ministries, departments can consider requests for compassionate appointment even where the death or retirement on medical grounds took place long time back, say 5 years. While considering such belated requests, it should, however, be kept in view that concept of compassionate appointment is largely related to need for immediate assistance to the family of the government servant in order to relieve it from economic distress. The very fact that the family has been able to manage somehow of these years should normally be taken as adequate proof that family had some dependable means of subsistence. Therefore, examination of such cases would call for a great deal of circumspection. The decision to make appointment on compassionate ground in such cases may therefore be taken at the level of Secretary of Department Ministry. Then, my lords, will see widow appointed on compassionate grounds getting remarried. Now,
This is not relevant.
so therefore, my lords, then my lords will see paragraph page 79, undertaking for a maintenance of the family of the deceased. So, my lords, there is it is a very extraordinary provision which is intended for ameliorating distress. And my lords, a decision has been taken, my lords, in this case by the screening committee twice. And it is not their case that they have been discriminated against or that somebody who is similarly placed has been given this benefit. So therefore, my lords, in my humble submission, they do not have a legal right, so to say, to seek relief from the court. If today there are
But
no
you had in
vacancies-
fact offered a job to him earlier.
Yes, but he did not apply then. At that time vacancy was there. Now there is no, then
Page
without-
42.
Yes, my lord. If there is no vacancy, my lord, then he did not take that home guard volunteer.
Willingness was invited. That was not done admittedly.
Further, you are informed that few positions of home guard were available. If you are interested, willing to enlist, you may give your willingness to the undersigned at the earliest. I am told that willingness was not given.
This is admitted, I think, Mr. Jacob.
No, we have given at page 41 that I'm saying that page 44. No, what nothing more is required. It's 8/21/7. It's dated 17 December 2015. My willingness was preceding this page 42, my lord. My request was made promptly. It hardly makes difference, lordship, if I make willingness after page date given at page 42.
Willingness
That's
was
for a-
invited.
That's for
After
a
that.
different job. How can it be a general
Willingness
kind of
was invited.
My lord, may I say one thing?
offer and accept?
I have the judgment which I've cited, even if there is no post available, they can create, my lord, supernumerary post.
Provided they are eligible.
True, my lord, true,
Yes.
true, my lord, true. This is not the case of the authorities that I'm not eligible. This
We'll
was never
consider.
been raised.
We'll consider, that's all.
Eligible and vacancy, my lords, and if at all, my lords, in my humble submission, if today, if there is a vacancy, my lords, perhaps there could be a case of considering their representation or something like that, but
So there is no vacancy now.
at least my instructions are in the police department, there is no vacancy. As far as home guards are concerned, I can accept it if there is a home guard vacancy. Right now, there is no vacancy, they are saying.
Even in the home guard category, there is no
Even in
vacancy.
home guard, they are saying there is no vacancy, right? But still, I mean, if it case is to be considered, my lords, it can be treated as a representation. If there is a possibility, my lords, it can.
Representation will yield the same result, isn't it? You are aware.
But my lords, if there is no vacancy, then how can, my lords, where will we create a vacancy, my lords? for-
Have you seen this judgment? The Supreme Court judgment. Please take over.
No, no, I'll give you a pass. Paragraph 9. Paragraph 9.
But this is subject to eligibility.
No, sir, obviously. Paragraph 9, last two lines, supernumerary patients to be created. Posts are not there.
Please send this entire file to.
Here for this statement.
Petitioner,
State is a respondent along with other.
Your lordship, in this matter, my seniors from Calcutta is appearing for the appellants, your honor,
appearing for,
appellants, your honor.
yes, are they appearing virtually?
No, your honor, today I am seeking adjournment, your honor, that the date may be fixed on 19th October, your honor. They are,
19, the last day,
yes, your honor.
well,
Lordship, also one submission, I would be representing the purported accused persons in this matter other than the states. Your Lordship, no service has been made from the petitioner's side yet, Your Lordship. Nothing has been made.
time application,
Yes, your honor. Yes, your lordship.
438.
439.
Cancellation of-
your honor. Cancellation of.
Oh,
a
this is
bail.
cancellation.
Anticipatory as well as regular bail granted to the accused persons. filed by the complainant.
You've received a copy?
No, no, your lordship, nothing has been served.
You've not served the accused?
We have served to the,
Where is your affidavit?
Your Honor, I have filed this, I have filed your Honor.
Where is the affidavit of service? Is it filed?
Yes, Your Honor.
No, where is it? It's not on record.
I
It's
think
not on
it is,
record.
it is on proceeding, Your Honor. I have
So
already,
you have not filed, Raman.
I have filed
Why do
it.
you say that you have filed? You have not filed it, isn't it?
I'll go and check it,
New
Your Honor.
application.
My
You're
present
applying for service, yes. Have
Okay,
you received the
state,
copy?
I have received the copy.
You received the copy. This is an application under section 439 within bracket 2 of the Code of Criminal Procedure. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. Can you complete service by 19?
Yes, Your Lordship.
Let the matter appear under the same heading on 19.
My presence will be recorded.
Yes.
Oblige, Your Lordship.
Oblige, your lordship.
This is an application under section 407 of CRPC. This relates to the item number 1. The FIR is of West Bengal. The allegation is of Andaman. So I want the transfer of that proceeding, which is pending in the Additional Chief Judicial Magistrate Court, Kharagpur, to competent criminal court in this island. And I have created some.
In this matter, my lord, although a review has been filed, there are two matters, my lords, item 6
Yes.
and 7.
Yes.
Now, a review has been filed against the order whose contempt has been alleged, but a special leave petition has also been preferred.
So let us wait for the
So
result.
I think if it can be kept for next.
Yes.
My lord.
It is submitted on behalf of the you are the applicant in the review application, isn't
Yes,
it?
ma'am. Yes, ma'am.
On behalf of the applicant in RVW 2 of 2023, that special leave petition filed before the Honorable Supreme Court is in connection with this matter is pending. Paragraph, by consent of the parties, the matter be placed before the next available circuit bench.
No, let it be on the prayer of my learned friend. Will you actually give my consent? Because
Very well, very
also
well, very well. On prayer of the applicant in RVW such and such, the matter be placed before the next available circuit bench.
Been transmitted to the principal bench.
Yes,
But during this interim period, no forcing steps, I'm not that, can, it's a 490 case, but
Cannot be taken,
I understand.
cannot be taken. Appear before the case.
audacity of the authority needs to be seen. In the first round of litigation, not the fact is, my property has been taken without setting the acquisition proceeding in motion. I made the representation when nothing was done, I approached this court. Not kindly see that order first. But it starts at page.
A report was called for. Are you ready with your report?
They are filed.
Report is already filed, my lord, sir.
I do not find is the report on record? Oh, yes, it is.
On 25/9.
Right, right. Cancel. Oh, right. Yes,
Page 32 may kindly be seen.
yes.
Now, kindly turns to page 33, the operating portion version.
It has been utilized without acquisition.
Yes, ma'am. Yes. This court in the first round simply relegated the matter to the deputy commissioner to take a decision in the matter within certain time limits. Not 33 second paragraph, I'll place it. Considering the facts and circumstance of the case as appears from the record and submission of the party, the writ petition being WPA number 285 of 2023 is disposed of, directing the deputy commissioner, Port Blair, respondent authority concerned to consider and dispose of the aforesaid representation being annexed B2 to the writ petition in accordance with law and by passing a reason and speaking order after giving opportunity of hearing to the petitioner or his authorized representative positively within a period of 10 days from the date of communication of this order, and in case of failure to dispose of the aforesaid representation within the time stipulated, the authority concerned will not be entitled to carry any work over the plot of land in question till disposal of such representation. The respondent's authority concerned shall also take steps for demarcation of plot in question in the meantime. Now, till now, no decision has been taken by the deputy commissioner. No final decision has been taken. This is one aspect.
What does the report say?
Report, they have, just to misguide the entire thing, they have undertaken an exercise to amalgamate my land to a particular survey number. Malad would find this at page 18. Because amalgamation in this island is nothing but to merge it, Malad. It's nothing but merge. This was never directed by this court. Amalgamation was never directed. They have invoked a provision, rule 41. I'll just show the rule 41. First of all, the report at page 7 may kindly be seen, my lordship. Report at page 7. And my lord would see page 7. Note number 17 may kindly be seen. Note number 17, left hand side margin, note number 17.
Yes.
My lord would see, I'll just place in these 4 lines. The survey was conducted in respect of survey number. So also this is the subject land note. And it is found that measuring area 201, 527, 147 and 40 square meter, respectively total area 915 square meter of land affected due to widening of national highway route. So Malashya, this is exactly my cases. You have not set the acquisition proceeding. There was no requisition made by the national highway, Malashya. They have taken. They have admitted this fact. The authorities, while holding demarcation, they have admitted it. This is one part. Ultimately, my lord, at page 18, my lord kindly turns to page 18.
Of the writ petition.
And of the report, they want to cover up the entire issue. What they have did, my lord kindly see. It was never directed by this court. Page 18, my lord, at the top, my lord.
Yes.
Further report reveals that land bearing survey number 85/1, 86/1, 87/1 and 90. These are the lands in question in the subject
Yes.
data. Are same soil classification and lying vacant. Accordingly, the above said survey numbers are merged into a single survey number 90/1 under provisions of LR and LR 1968 Rule 41. So this Rule 41 is nothing but it's a provision dealing with amalgamation. It was nobody's case in the first round. Even before this court, now it was nobody's case. My simpliciter case was, you cannot take my land property the way you like. You set the proceeding in motion. If you do not take a decision, the court held, if you do not take the decision within 10 days, no work to be done. No decision taken, but the work is in full swing now. And they have brought this report on record, showing that we have did our work. Now kindly see Rule 41 once. They have invoked this provision to prepare this report. Now kindly see Rule 41. second part of the regulation needs to be seen, not it's regulation rule 1968.
Yes, yes.
But two or more occupied survey numbers as may be amalgamated, provided the following conditions are satisfied. Namely, number A, the total area does not exceed 10 hectares. That's the first condition. B, the tenant or tenants of each survey number and the type of tenure are same and they agree to amalgamation. C, there are no subdivisions, and D, the common boundary is such that the amalgamation will materially facilitate cultivation, provided that the limits imposed by or under the condition A may be exceeded to such extent as the settlement commissioner may by general or special law sanction. B, the combined survey numbers shall be given the numbers of all the survey numbers which have been amalgamated to form it the various numbers being connected V hyphens. Lord, 41(1) B is very much relevant.
Yes.
Lord, this says it was nobody's case of amalgamation. Even then, for the sake of argument, also it would come into play only when
Consent.
I agree. Lord, this is first aspect. Second, Lord, second condition is the type of land must be one and same. Language of 41(1) B is the tenants or tenants of each survey number and the type of tenure are same. Well, now kindly see the land records which have been appended to the writ application. 15, Lord.
15(1)(5)?
1(5), annexure P1.
Yes.
My lord, the first, there are several survey numbers. The first one is 15 comprised of 3 survey numbers. My lordship, at the top, 81 survey number I've got 81 in the name of my client Mahesh Kumar Agarwal.
Yes. Yes.
Next is the nature of land, nature of right, its occupancy. Survey number is 81. Area is mentioned. Then soil classification P1 means paddy 1. Nature of use paddy. Down below, my lord. Next land survey number is 85/1. It's commercial. This has nothing to do with occupancy. Next, my lordship. Third one, commercial 86/1. In the same way, next
These are all commercial.
commercial and occupancy.
Next is hilly.
Yes. Well, in view of 41(1)B, to set this amalgamation, all the properties have a same classification. This is not the thing.
And the rules say amalgamation is for agricultural purpose. only.
Absolutely not. Absolutely. This was nobody's case. Not the direction was, no, that's why I said, I started my argument with saying, Lordship, this is the audacity. This court simply directed Deputy Commissioner, you take a decision before doing it, hold the demarcation. That's it. From the demarcation, this fact would be unearthed. The quantum of land occupied by the other side, the authorities. In one part of the report, they say that this has been used without acquisition proceeding. But ultimately, just they have messed up the entire issue. They have invoked this 41 and they filed the report before this court. I would pray, Lordship, that the appropriate order, what I've claimed in the writ application, has to be passed on my ship. What my prayer before this report is, my lord, I'll just show. Prayer 2 may kindly be seen, my lord.
Yes.
A writ in the nature of mandamus commanding the respondents' authorities, more particularly the respondent number 3, Tahsildar, Fargan Tahsil, Portrait to hold and conduct demarcation of occupancy land bearing survey number 86/1, measuring area 0.024 hectares, situated at Dhannikari Revenue Village under Fargan Tahsil, strictly in accordance with law by restoring the quantum of subject land from unauthorized possession of respondent number 4. Then, my lord, a writ in the nature of mandamus commanding the respondent's authority to prohibit from proceeding further with any construction over occupancy land measuring so-and-so area so-and-so lordship at Dhannikari Village. And I prayed for interim order.
Let us hear this.
My lord.
Yes.
Here, my lordship may kindly have a look at the report, my lordship.
Yes.
In page number 4, I will give a legible one, my lordship.
Page number 4.
4, my lordship, of the
Right.
report.
Yes, it's not legible at all.
Yes, my lord, I will give. As per which, my lordship, the village, which is recorded in the name of this writ petitioner,
Yes.
it is under revenue survey, my lords. And revenue survey is required if as per regulation 61. For a period of 30 years, if the period is given, my lordship, limitation period, in order to see whether any new development has been done or not. For that, a revenue survey is required. And as per this notification dated 20 July 2011, my lordship, the Dhannikari village, it was under revenue survey, and it was till today it was not closed. This has to be closed. So what happened, my lordship? The revenue survey was required. Since, my lordship, there is a dispute is there. regarding the possession. Now, my lordship may kindly have a look in rule 38. Just above rule 41, my lordship. When the may I read out, my lordship?
Yes.
When the actual boundary of a survey number does not agree with that shown in the field map, the map shall be corrected in accordance with boundary as agreed or by the parties concerned or as determined under section 97 of the regulation, my lordship. Here, my lordship, there is a dispute, so there is no requirement to consult even the petitioner, my lordship, because there is a dispute. Now, my lordship may kindly have a look in.
But does it say that in case of a dispute, there is no?
I will show my lordship. In
necessity to
97, it
consult
is there, my
petitioner?
lordship. In 97 of the regulation, it will be available.
Yes,
My lordship may kindly have a look of regulation 97.
97.
It is regulation, it is not rules, my lordship. Land revenue and land
97.
reforms regulation. It starts from all, my lordship got it, my lordship?
Give me a minute.
Yes, my lordship. It is page number.
Yes, 97.
All disputes regarding boundaries of village and boundaries of survey numbers and plot numbers where such boundaries have been fixed under the provision of section 96 shall be decided by the deputy commissioner after local inquiry, at which all persons interested shall have an opportunity of appearing and producing evidence, my lordship.
So have you complied with this? Opportunity of hearing and producing evidence?
Here, my lordship, due to resurvey, my lordship, it is not
So
required, my
whatever you're
lordship.
submitting is going against you, you realize
My
that.
lordship, regulation 61 is there, my lordship. In my support, I will. Because this village was under resurvey, my lordship. The first one, subsection 1. The term
Regulation 61,
61, my lordship.
yes,
The terms of settlement shall be fixed by the government and shall not less than 30 years.
yes,
Yeah, so what happened? The period is there, my lordship. If
not less than 30 years,
30 years, my sorry, my lordship.
minimum 30 years.
Minimum 30 years. So as per this notification, my lordship, this village Danikari, which is placed in page serial number 10, it was under revenue survey. So what happened, my lordship? Thereafter, as per the direction of this honorable court, we have done the demarcation. And in the demarcation, what it came out,
There was the direction of the honorable court to conduct demarcation. There was a
Yes, ma'am.
direction for consideration of representation.
representation along with demarcation is to be done, my lordship. Demarcation, my lordship may kindly have a
Was
look.
that done in presence of the petitioner?
Yes, my lordship, is power of attorney, he used to appear.
Please show me the document. The relevant document.
My lordship, it was not annexed. I have got the notices.
This way, these papers cannot be brought in.
So
record.
it was,
This
it was wrongly not
This can't
annexed.
be done this way.
My
There is
lordship,
the order disposing of the representation
I'm
as
reading,
directed
I'm
by the, by this court earlier.
that is there, my lordship, in page number.
Page
I will
number.
show my lordship. This writ petitioner, my lordship, the representative of the writ petitioner, he used to appear.
There is the order.
Order is, my lordship,
That disposing of the representation.
that is not.
You should have faced contempt by now, sir.
My lordship.
You are lucky that the petitioner has spared you.
My lordship, I will show one paper, my lordship. Page number 17, my lordship.
Of the
It is,
report.
yes, my lordship, in the report.
Yes.
It is the revenue order sheet, my lordship, with the proceeding.
One line to show that you have disposed of the representation in compliance with the order of the court. One line in the order.
On my lordship. Page number 19 may be seen, my lordship, the last two paras.
Yes.
The survey, the S&D survey hereby directed to prepare records accordingly and erect permanent boundary. This was done, my lordship, so entire order sheet shown, my lordship, it starts from 17 to 19. And the representative, they appeared before us.
In the order of survey also, there is not one line which says that the tenant was served with a notice or either appeared or did not.
My lordship, notice is lying with me, my lord.
It should be reflected in the order
Yes, my lord.
that the tenant was heard. You have admitted that he is a tenant. There is
Yes,
no
my lord.
dispute with regard to
Yes,
the
my lord.
fact.
No, my lordship may kindly have a look of one page, my lordship. Page number 9 of my report. This is in respect of compliance report regarding the demarcation, my lordship. The demarcation has been done. In respect of part compliance, in respect of the demarcation, my lordship.
The order was in WPA 285 of 2023,
Yes, my lordship.
where you have referred to some other numbers. Please find out.
This is new number, my lordship.
This is an order passed on February 22, 2023,
Yes, my lordship.
which required compliance.
Yes, and the demarcation was done on 6/9/2023.
You have referred to other WPAs and order passed on 28 July. Maybe that was for direction for demarcation.
No, my
This
lordship.
order doesn't direct to demarcation, it only directs disposal of the representation.
The
You have not referred to the order at all. Please,
No, my lord,
page
I-
9.
My one, my lordship. Yes, my lordship.
Yes,
There is no,
so this order
Due
has
to-
not been complied with.
yes, my lord, due to which, my lordship, we have
Comply
given.
with the order immediately. I give you 2 weeks' time.
Yes, my lordship.
And pending disposal of the representation, nothing, no kind of encumbrances will be made on the petitioner's land.
Okay, my lordship.
In terms of prayer 4, my lord, at page 13, what I prayed in.
Page number 11, please see, my lordship, for a moment.
11 of your report.
Report, my lordship. Here, my lordship, the demarcation has been done. Thereafter, what found? This writ petitioner, my lordship, is in excess area.
You take a decision, that's what.
That I will do, that they will
Take a
take,
decision.
they will take
Not
it.
also be.
They will take it, take it.
Don't support the authority like this way.
No, no.
The writ
And
court has
none of the
directed-
documents pertain to the writ petitions, either the present one or the earlier one. And they also do not support your case, sir. I'm sorry.
Yes, my lord. The demarcation was done, my lord, wherein it has found that he was in excess.
You are only on demarcation,
Yes,
which is not the issue at all,
yes, my lord.
isn't it? Consider the representation in terms of the earlier order of the court.
Yes,
Within 2 weeks, that should be sufficient.
yes. Sir.
Upon hearing the
Instead of, my lord, say, 1 month.
1 month, very well. Heard learned counsels for the, do you have anything to say in reply?
Nothing more to add.
Heard learned counsels for the parties. Paragraph. It is not in dispute that the petitioner is the recorded tenant of an occupancy land.
It's commercial. 86/1, this pertains to survey number 86/1, it's a commercial.
Pertaining to survey plot number 86/1, measuring about 0.0248 hectares, situated at Dhanikhari Revenue Village. In an earlier writ petition filed by the petitioner, being WPA 285 of 2023, a coordinate bench of this court, comma, by an order passed on February 22, 2023, comma, directed the Deputy Commissioner, comma, Port Blair, to consider and dispose of the representation submitted by the petitioner before the authority and pass a reasoned and speaking order upon giving opportunity of hearing to the petitioner or his authorized representative within 10 days from the date of communication of the order. Stop. Paragraph. A report has been submitted. No, paragraph. A learned counsel for the petitioner submits that the said order has not been complied with by the respondents till date, who are, comma, who are continuing with construction work on the petitioner's land without acquiring the same by due process of law. Paragraph. A report has been submitted on behalf of the respondents, which demonstrates that survey was conducted in respect of the plot in question, and it was found that portion of the land was affected due to widening of national highways, due to widening of the national highway. So, small letters, huh? Paragraph. It is not in dispute that the petitioner is the recorded tenant of the plot in question. Stop. There is not an iota of document on record to suggest that the earlier order of this court has been complied with by the respondents. Stop. In fact, learned counsel for the respondents candidly submits that the representation submitted by the petitioner is yet to be considered by the authority. Stop. Much has been spoken by learned counsel for the respondents regarding demarcation of the plot in question. Stop. Such demarcation, comma, as it appears, comma, was not done in presence of the petitioner or his authorized representative.
Was done in presence of them.
Yes,
It was done in the.
your report doesn't say. Your report doesn't say so. One line in the report.
Yes, my lord.
Therefore, such demarcation allegedly done behind the back of the petitioners can have no bearing upon the petitioners. Paragraph. Since the representation submitted by the petitioner before the respondents is yet to be considered, comma, the writ petition is disposed of directing the concerned authority, being respondent number.
Deputy Commissioner is respondent number, my lord. 2 more.
Being the second respondent herein, comma, to consider and dispose of the representation within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. Pending disposal of the representation, the respondent authorities are restrained from causing any encumbrance upon the plot in question, including utilization of the same, comma, excavating earth or raising construction. Paragraph. Writ petition disposed of, and those 4 lines.
Blair.
Oh, my lord.
Next.
Item 3, WPS 672 of 2023.
Same order, save and accept the details of land and the order in WP case number. It would be changed. Rest is would be same. Here survey number is 88 and 89.
Yes, the same order.
Same order.
You have filed a report here.
Yes, my lordship. Report is there.
Where is your report? There's a report in this matter. Has a report been filed in this matter?
There are 4 cases, my lordship. In all the 4 cases, they have filed it.
You filed reports.
Yes, my lordship.
I do not find a report in this matter.
ये कौन सा number? The case number?
The time to file report was extended. After that, no report has been
We have
filed.
filed in my lordship. It is filed in the office of registry in all the 4
They
cases.
have been served with the copy.
Even the copy has
They have
been served to
served
the
with
other.
Same report,
Where is the
same.
report?
Same report.
Same.
Same. Only 7.
it has to come on
Yes,
record.
I understand. Let it
Yeah.
come tomorrow, ma'am. But
Please
there are
find
other
out.
two matters coming tomorrow. So let these. be-
Similar matters?
Similar.
Not today.
Yeah.
Yes, ma'am. God bless.
In the other two matters also, please ascertain whether the reports are there on file.
Not-
Otherwise, they cannot be taken up.
But there is one indulgence. Those two matters were before court number 2 and it got delisted. Not just I'm mentioning it for inclusion with this matter. My lord.
Please keep all these three matters at the top under the heading motion. Right?
I'm appearing for the official respondents.
Sir, I'm appealing for the petitioner. We are supposed to file the supplementary affidavit by annexing the power of attorney order. But my client is out of city, my lord. So I couldn't, let it be on Monday, my lord, I filed. Let it be on Monday. Was the,
Who is appearing for the private respondent?
Yeah, for the private respondent, lordship.
You wanted to come back with a supplementary
my
affidavit?
lord, annexing the power of attorney order was
Service is complete because everyone is appearing. I
Yes,
find the
everything
recording
the
for
matter has
service is
been
not complete.
taken up, but the, because of filing of the
Very well.
power of attorney.
Tuesday,
Tuesday.
right?
None. Okay.
On prayer of the petitioner, liberty is granted to use a supplementary affidavit. Annexing relevant documents,
So, power of attorney.
annexing relevant documents.
None.
Paragraph, let the matter appear under the same heading on 17th.
Grateful.
Obliged, my lord.
Matter, my lord, we had
Yes,
filed our affidavit in opposition, my lord.
the next matter, right?
Yes.
This is the matter where payment was to be made for work done. Your lordship had heard me briefly. Now today, I just need to point out to your lordship, whatever I submitted yesterday, just to give the background because my learned friend was not there, I need to demonstrate it.
There's just one aspect I would like to point out, my lords, that there, my instructions are
Why
that
do you want to come back with an affidavit in opposition? in this matter?
it's already filed. I'm saying, I was wondering if they would like to file a reply to the affidavit in opposition.
They have to, I think,
No.
not necessary.
I submitted yesterday, madam, the affidavit in opposition. There are three things. The first thing is, it is claiming that we need to add in certain persons as parties, which is not to be done in an affidavit in the first place. If they wish that to be done, they have to take out an application. So that is out of place. Second thing is, apart from a bold allegation at paragraph 4, where they have said the reputation is not maintainable and should be dismissed, they have not controverted any of the statements I have made. If your lordship sees paragraph 4, at the very outset, I say the reputation is not maintainable and not to be dismissed. But thereafter, contradicting themselves, they go on to say that we should make all these other persons as parties, the Minority Affairs Ministry and Delhi. And additionally, they go on to talk about how there is another writ petition which is pending before this court on a similar issue. So there are contradictory statements. If the writ was not maintainable, the question of making people parties and saying that it is connected to another writ petition would not rise. And the third thing is that most of the documents they've relied on have admitted my case. And I just need to demonstrate that. If your lordship would come straight away to page 8. Now. at
Page 8 of the writ
of
petition.
their
There are,
application, I'm putting it there.
yes, yes.
I will just point out the connection between that and my writ at page 6. If you also keep my writ petition page 6 open on one side, then it will be very clear.
So I think that you've completed the work and payment is awaiting is not actually, not
It's
really in
not
dispute.
controversial. It's not.
My lords, the submission is, my lords, there is an arbitration clause, my lords, which has not been disclosed. Even by us, my lords, but I have received the instruction. Secondly, my lords, that here, my lords, the funds have to be released by the ministry. So in case of a similarly placed contractor, my lords, we have annexed that order at page 32 of the affidavit. My lords, this ministry in notice has been issued to the ministry. So my lords, in my humble submission, my lords, that because the funds have to come from the ministry, my lords, we are only the
It's
state
between
government.
you and the ministry intersays.
No, it is not, my lords, this is a central, the funds come from the central government, from the central ministry. It is not like that, my lords. They are independent. Administration is not acting, is acting as a state government in this situation.
With all work that we have done on rent, this was not the correct position as disclosed from his own records.
And the work was also carried out under a central government scheme. So if there are no funds under the scheme available, my lords, we can only give from the funds which are made available.
It's not your responsibility to make such funds available.
No, my lord.
Aware that the work has been done,
My
completed.
lord, yes, my lord. So we are pursuing with
So you have no responsibility at all?
no, my lords, we are pursuing with the ministry, my lords, but eventually the ministry is is not subservient to the administration, my lords. We have been writing to them, my lords. We are pursuing the matter. But my lords, if they, it will only resolve it matters much quicker
Because the
because,
small issue involved herein is payment,
yes, my,
right?
my,
And you admittedly, they have completed the work.
my lord.
There's more to it. So let's just take up page 6 of the writ petition and page 8 of the affidavit. Now, Leonard, this
Yes.
is probably not fully instructed. His own documents disclose a different story. Page 6 of my writ petition, there are 4 ABCD.
Yes,
ABCD are the 4 projects which he was dealing with. Now come to page 8 of
yes,
their affidavit. This
Yes.
is the letter of 26 March 2020. In terms of provisions contained in clause so and so, the Secretary, Social Welfare Administration, Port Blair, has been pleased to transfer an amount of 182.18 lakhs to the Executive Engineer, NACD Mayabandar, account number so and so, for construction of different projects. The above amount sanctioned is subject to the condition that the same shall be utilized for the purpose as mentioned in the annexure and shall be utilized with per expenditure sanction of competent authority. The expenditure is debitable with account number so and so. Now the annexure with that kindly see at page 9. Serial number 1. Serial
Yes.
number 1 may be compared to my A,
B,
my B,
B.
Kamlapur.
yes,
Serial number 3, Harinagar and Shantipur may be compared to my A and D. Serial number 5, Horatan, may be compared to my C. And on the side, whoever filed this affidavit, on the side, there's a noting which they have done, indicating which of my projects are against which of these. So this letter discloses the money has come from the center to the administration, 182 lakhs. The money has gone from the administration to Mayabandar Executive Engineer. This is not a case similar to the other contractor where money is awaited from the center. Here, money has come from the center. It came to Port Blair. Port Blair has sent it to Mayabandar. It has to be disbursed to me. This is why I said, A, this is not a case of unpaid bills. This is a case where money has gone missing. Because this money, as per the order, sanction order, could only have been used for the purpose for which it was allocated. A. B, in this situation, I have made prayers in my writ petition and in my representation before the LG and the Chief Secretary that this is not a simple matter of some non-payment of bills. There is something more to it than 182 crores can go missing. It's not a small amount. And thereafter, you also will see the next page, page 10. This is Mayabandar. My case is Mayabandar. The 2 documents at page 8 and 9 are Mayabandar. Thereafter, page 10 are documents related to Wimbaliganj,
yes,
Karnikobar, Rangat, and Mayabandar. Kindly see point number 4 at page 10.
yes,
Executive Engineer, 1 crore 82.
the same figure.
It's the same thing. So therefore, the money has come from Delhi. It has been released by Port Blair authorities to Mayabandar. Somewhere between Port Blair and Mayabandar, it has got lost. This requires perhaps an inquiry, an investigation by the relevant investigating agency, if not the administration's agencies and perhaps the central agencies. This is not a small amount. Now thereafter, kindly see the next page, page 11.
Yes,
They are talking about an amount of 1132 being released. 1132 is the sum total of the amounts mentioned at page 10. Therefore, the amount that is the same amount, 182, as per this letter, is admittedly released by the ministry. If you read page 10 and 11 together, my lord, we'll come to that conclusion.
11.32 is the first installment.
No, my lord, 11.32 is the sum total of 1, 2, 3, 4, including the 180.
And 182 is the entire fund.
182 is the fund, serial number 4, which was intended for my bundle. And that 182 is clarified at page 8 and 9, which includes my projects. Therefore, the chain of their documents indicates 11.32 came from Delhi to Port Blair. Out of that, 182 was meant to go to my bundle. It went to my bundle. Out of that 182, I'm supposed to pay 80 something odd, 80 or 90 lakhs odd. So the money is not sitting in Delhi, as my learned friend would like us to be.
What is your prayer?
Now, if your lordship sees page
22 is
22 and 23. 22, I have asked for a mandamus because the money is there as per their own documents. Now they have demonstrated it is to be disbursed to me. Number 2 is I have asked for the matter to be taken up for disbursement of funds and implementation of the scheme. And I have made a specific prayer that my representation be taken up at the highest levels. If your lordship sees page 57, para 11.
That's your representation?
My representation starts before that, man. The relevant portion is at 57. It's at page 53. Representation dated 27th February 2023. Now the relevant portion, I've described everything. The relevant portion also will get at page 57, para 11,
Yes.
13, 14. Let it be examined as to why money earmarked for this contract, part of a national level scheme in the name of the Prime Minister, has gone missing and is not being disbursed to me, even after doing the work, which is the intention of the scheme. Now, what is interesting is, A, the work is admittedly completed. B, the bills are admittedly sanctioned. C, the money came from Delhi, was released by the minister.
Only the payment parties are waiting.
That's all I'm waiting. Now,
Yes,
technically speaking, this inquiry and investigation is one thing. In fact, I do not know, my learned friend was not here. The documents they have annexed are showing huge amounts at variance. If your lordship sees the next set of papers they've annexed from page 12 onwards, this fact needs a severe investigation.
But that doesn't concern you.
No, I'll tell your lordship why it concerns me. They are talking about the fact that there's no money, it has to come from Delhi. If your lordship sees each of the districts, crores have come into Port Blair, some of it has been spent, and as much as 300 crores is unutilized. Where did that 300 unutilized crores go? Even assuming that they say they have that the money due to me has not been released, let us assume that to be correct. Then out of this 300 crores that should have been paid because that is the central fund for the same purpose. Now, the administration claims there is no money. In fact, the central ministry has written, as per their document at page 20, saying all your accounts are not tallying up. Please settle your affairs. Can we see page 20, the letter dated 17th March? This is coming from the Secretary, Ministry of Minority Affairs, to the Chief Secretary. Kindly see paragraph 5.
Yes.
That there are discrepancies in the utilization certificate. It cannot be reconciled. There are mismatches in the amounts in the projects. So therefore, on the next page, your lordship will see page 21, why the money is stuck in Delhi. Not that it concerns me, because my money has already come here. Para 8, last 3 lines.
So let us not deal with this.
If the scope is expanded, then I would like to file an
No, not
affidavit. It's
necessary.
all
Not
past the-
Expanding anything, you have fixed these.
So that is, the-
Let us,
therefore I have
let us
nothing to hide.
confine ourselves to the periphery of this
The only
petition.
reason I'm going this far is because the submission being made that the money hasn't come and the documents are saying something.
No, that you've shown.
Now kindly, my
As
lords,
far as you are concerned, you have
I'm
dealt with it. Yes,
now my lords may see my affidavit in opposition.
yes.
My lords, para 6 onwards. My lords, it is a specific, this is a state case in on affidavit, my lords. So the petitioner was awarded 4 tenders under centrally sponsored scheme of Ministry of Minority Affairs, and the details of the tenders are given. Then my lords will find at page 3, para B, on completion of the aforesaid work, contractor submitted the bills and then the
Yes.
computation is given. Then my lords will see para C, total 19 number of works were sanctioned by PMJVK, that is under the central ministry, under NACD, APWD, Mayabandar for amount of 4,54,11,232, against which first installment amounting to 1,82,18,000 was released with the order of Social Welfare Department. And that letter, your lordship will also find, it is annexed at page
It doesn't say it's the first installment.
no, I
The letter, the order.
Yes, but we have.
Page 8.
Page 8 is that will come in the subsequent correspondence, but my lords will see page 8
Yes.
is issued Urban and Equine Administration Directorate of Social Welfare. And my lords, this says that in terms of provisions contained in such and such, the secretary is to transfer amount of 182.18 lakhs to executive engineer for construction of different projects as per fixture enclosed. Then the above sanction is subject to conditions, same shall be utilized for purpose as mentioned and shall be utilized as per expenditure sanction of competent authority. So my lords, after this, the amount that first
It
installment.
doesn't say that it's the first
It
installment.
doesn't, this is our letter, which comes later on, it's the administration's letter, my lords, administration is given an affidavit, my lords. The amount received as first installment is utilized for payment of completed works as on 26th and after utilization certificate was submitted for first full installment. Work undertaken were in progress. Petitioner did not submit any running account bill for making payment for any partly done work. After
You're at page?
Well, that's page 4 of my affidavit. I've said that the
Yes.
works undertaken by petitioner were in progress and petitioner did not submit any running account bills for making payment of any partly done work after completion of all the works implemented under the scheme. A utilization certificate for payment received as first installment submitted to Social Welfare Department. The compiled utilization certificates were sent by the Social Welfare Department to Ministry of Minority Affairs on 13 June 22. My lords, that letter, your lordship will find at page 10. Now, and my lords will see on the next page, page 11, out of the total sanctioned amount of 24.09 crore for implementation under Pradhan Mantri Jan Vikas Karyakram, only an amount of 11.32 crores was released by the ministry. Full stop, the Andaman Public Works Department Construction Agency informed that construction work of 39 Anganwadi buildings are completed in full shape out of 46. Therefore, it is requested that the balance amount of 12.77 crores as second installment for implementation of works projects under Pradhan Mantri Jan Vikas Karyakram be released at the earliest. So the administration is writing to the Ministry of Minority Affairs that kindly release the balance amount of 12.77 crores. Now, managers will see after this that the ministry at page 5 of the affidavit, Ministry of Minority Affairs letter dated 17th March 2023 has pointed out discrepancies in utilization certificate and requested to furnish the revised utilization certificate.
You are in the entire scheme, the entire project. The petition is confined to only the petition.
Yes, but first, my lords, my submission is, my lord, that the ministry has now written back to us saying that there are discrepancies, and this letter my learned senior was showing, my lords, it may be, if your lordship.
Please come to page 10.
My lord.
Column 4
Ma'am.
of your report.
Yes, ma'am.
1.82 was sent to Mayabandar.
My lord.
Yes. Utilization was 1.66.
My lord.
So what was the difficulty in disbursal? The petitioner's claim is less than 1.82.
My lords, this is explained, my lord, if my lord sees.
Only with regard to Mayabandar. I do not want to go into the other projects.
My lords, let me
Because
come.
here it has been separated.
Yes. I
Please
appreciate.
pay, sir. You have no other option.
My lords, let me come back tomorrow, my lords. I'll come back with instructions.
I hope I've made myself clear.
Yes,
Yes, for Mayabandar, they have received 1.82.
yes,
The petitioner's claim is about 80-90.
yes, ma'am.
So why hasn't this been paid? Where did this amount go?
Yes, ma'am. I understand, ma'am. I'll get back.
Twofold prayers, consideration of representation
Yes, ma'am.
and payment of the amount.
Yes, ma'am.
Yes,
Yes. ma'am. I'll come back.
third learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration. Tomorrow, comma, that is on tomorrow's 12th. 12. Let it retain its position.
I pay for the respondent.
All the matters are being made. now.
Private respondents have been dispatched with the copy of I will ascertain from the track report whether the service has been effective.
Very
Come back with the evidence.
Obliged, my lord.
Not today. Friday. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th.
I am appearing for the respondent. Same with 8 also.
7 and 8, very good.
My lord.
Same order in 8 also.
I am appearing for the respondent authorities.
Petitioner? No one? None appears for the petitioner. Petitioners, no accommodation is sought.
My lord, I am appearing.
Yes. Yes, what is the matter about?
Lord, the petitioners are the full blood brother and sister. They filed an application before the respondent on the subdivision officer for the exchange of
Exchange of the
their land.
land.
Their land. Because the land being survey number 24/5, it is recorded in the name of the petitioner number 1. The area is same 226 square meter. And it is a house site. The land bearing survey 24/4.
The application has not been considered.
Not considered. Even long back it has been filed. And there is a specific provision under the rule in section 154 of the regulation 1966 that the subdivision permission is required from the subdivision officer.
Where is your representation?
Yes, my lord.
Annexure P2?
P2, page 50.
Yes,
My lord, it has been considered and it has found that some disposition is there of the land. And as such, the report has been called for from the Tahsildar. For the Tahsildar has to submit a report before the subdivision officer. So it will be done within
within a month.
within,
So let there be a direction
my lord,
for disposal within a month.
my lord.
The petitioners submitted an application before the first respondent seeking permission to exchange the land occupied by each of them in terms of regulation 154 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966. The said application is yet to be considered. The petitioners pray for a direction upon the authority to consider the application at the earliest. Where I said that the petitioners file an application, please give the date of the application. When was it filed?
7/4/2022.
On 7th April 2022. Paragraph, learned counsel for the respondents submits that in considering the said application, comma, a report has been called for from the
Tahsildar,
Tahsildar
This one number 2.
respond number.
/ the second respondent herein by the first respondent. Paragraph, upon consideration of the submission made on behalf of the parties, comma, the petition is disposed of, directing the first respondent to consider and dispose of the application submitted by the petitioners dated such and such within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of those 4 lines.
Obliged, lordship.
Next.
In my lord, service is not affected upon the private respondent.
So let it fix on Monday, my lord.
You'll come back next week?
I am appearing for respondent number one only.
Come back on Wednesday. Monday, several matters are fixed.
Okay, my lord.
Since service upon the private respondent is not complete, comma, let the matter stand over till 18th. Next,
Obliged, lordship.
Item 11, WPA 966 of 2020.
In this matter also, my lord.
same order,
Yes, ma'am.
same order in item number 11.
11 while I am appearing for the municipal authority.
The private respondent has not, there's a private respondent in the matter. item.
Yes, yes, I'm just informing.
He is seeking time.
My appearance may be recorded for
Sure.
the municipal authority.
Obliged, my lord.
Yes, next.
Second appeal has already been dismissed. I'm the respondent there. In the suit, I'm the defendant. This is proceeding under order 9. Second appeal was heard out in absence of my landlord, who was one of the defendants. If I could show lordship, that I'm prevented by sufficient cause because there are orders of this court, division bench court, which has allowed an identical application under order 9 rule 13 and the main case was divided.
An opposition has been filed.
Yes, Lord, I am for the appealing, I am appearing for the OP1 appellant. I filed my opposition.
You are the second respondent in the appeal.
Second respondent in the appeal.
Contesting respondent.
Request of-
Now, Lordship, the interesting thing is that the contesting defendants come for setting aside the expert order passed against the respondent number 1.
Take the pain
So it is not maintainable as per order 9 rule 30.
Curiosity, the moment I complete. Lord,
Yes,
I'll just show two cases. Lord, kindly tells us the order sheets. Lord, right from page, immediately after the affidavit part, and I'll show when the appeal was admitted and what was being directed by the court, and no notice was given, appeal was taken out of final. Lord, kindly takes the can application. I'll just show.
yes, yes.
Would kindly come to order dated 20th September 2019. Admitting the appeal by the division bench, second appeal. In order dated 20th September 2019, passed with SAP number 9 of 2019.
January 9, 2020, or
No, it's September 2019. Admission order, it's an admission by the division bench under 41 rule 11. Which is normally done under the effect sites, so for a second application. This was also done here also.
I do not find the September order.
My lord is speaking up.
The can,
Can.
yes.
Yeah.
First annexure is the memorandum. Then it's the December 19 order.
Number 19, yes. So kindly, same order sheets, you have to find by their lordship, Honorable Justice Ashish Kumar Chakraborty and Justice Madhumita Mitra. So, immediately after the order passed by
September 20 order.
yes,
Yes.
September 20. You have to
They are
find,
not arranged in order actually, so it's okay.
so by this order, the second appeal was admitted by framing substantial question of law. Subsequently, page next order dated 24th September 2019. My lord, appeal was admitted and again at this order 24th September 2019. A further question was formulated and my lord would see. I'll just show them. I would see an additional question was formulated on 24 September 2019. Then when the matter was before Justice commencing, on 23 February 2021, the notice was usual notice and the second appeal was direct notice upon both respondent number 1 and respondent number 2. I appeared for respondent number 2 because respondent number 1 happens to be my lord. That's why I came before the trial. The trial court dismissed the suit. The first appellate court dismissed the suit. In the second appeal, this was the order being passed. This court specifically directed the appellant, for whom Mr. Hon'ble appears here, to issue a notice. One would see this order dated 23 February 2021.
You were appearing all throughout before the court.
Only respondent number 2. But would see the order.
So here also you're representing respondent number 2,
Yes.
not 1.
No, but I am the tenant under the respondent number 1. We both have a common defense. We raise the common defense.
So 1 should have come forward. Why 2?
But I have been ready to serve notice. Not to see in this proceeding, upon 1, service was correct. So, the object of order 9/13 is not that there are 2 grounds. Sufficient cause by which one has been prevented when the matter is called on for hearing. Summons were not served.
The person who is aggrieved has to come before the court.
Order 9.
Yes.
But not can you see the orders passed in this proceeding?
How are you affected, sir? The person affected has to come.
So there are.
It's not maintainable. I'm sorry.
I can.
Lordship, I served thrice. I served.
No, so this court.
I filed the document.
No, that's later. But what is your locus?
So only for that reason, this court directed me to serve notice upon respondent number. Can you see the order passed in the present proceeding, in the can? I will place those 2
No,
judgments.
since in can you have impleaded the other respondent as a party, you have been directed to serve notice. That's technical. That's nothing on merits.
But I have to satisfy final question now. I have a locus to maintain the present.
Yes.
To come with those 2 judgments tomorrow. Let it be tomorrow. I'll place those 2 judgments. Even order 9/13 can be invoked. Lordship.
No, cannot be. Can you have a look, Lordship?
Plain language, if I go with
Can you have a look? The language.
If I go with plain language,
The person who is aggrieved and
plain language.
Lordship, intention of the legislature and the language employed in order 9 rule 13 is clear. The person aggrieved come before the court
Yes,
for
yes.
setting it aside. Against whom the expert.
in whose absence it was passed, against whom the.
Lordship,
I'll take
this is one
Please
point,
come.
maintainability point. Second, kindly have the look my opposition. I served thrice, even the registry has served.
Brother wants my people on merit, Lordship, I can do it. But-
Yes, you do. I appreciate.
It's
I appreciate.
primary on the maintainability point, your locus.
Lordship,
Let him
Kindly-
satisfy that point.
Lordship.
I don't intend to go into merits at all,
Lordship,
because even I am of the prima facie view, so let us see.
Lordship,
Even I have seen the concept of CPC. The plain language is very.
CPC
clear.
is here.
I cannot maintain.
CPC is here.
I cannot maintain. I know. But there is some judgments which even comes to my rescue and says it can be done. There is a common interest. In the suit, we are the defendant, they have common interest.
Lordship, I am reading the
Even-
particular line in
Even in that
CPC.
case, even in that
Lordship,
case.
in any case in which a decree is passed ex parte against a defendant, he may apply to the court
Yes,
for setting
yes,
it aside.
yes.
Language is
So,
very,
since I intend to pass an order against Mr.
Lordship,
Kirpal,
even there is
so,
a
let him
direction.
come back, let him come back.
There is a
tomorrow.
direction in the last order to serve upon the OP2. He did not comply. There is a connivance and collusion.
That becomes irrelevant. That becomes
I'm
irrelevant.
great.
The can has to be maintainable in the first instance,
I'm great.
not today.
Okay, since part heard, matter is part heard, let it be taken tomorrow, Lordship.
Making it only not today.
This was. Yesterday, there are bunches of matters. There are reports, in part has been challenged. No list of demarcation was given. That Reliance has been faced with certain reports, copy of it has not been handed over. Brought to see page 17, annex of report. This report not as a whole, because some part of the report, because applying the principle of doctrine of civil.
This is the other matter.
It can be used.
This is that regularization issue.
I the authority held certain demarcation in my absence, I'm the recorded tenant. They have not revised the land, not the report is standing in my case. Some part of the.
Pre-1942 occupier.
Yes. Report indicating that I have enforced government regulation survey number 103-101 is concerned, so I'm not agreeing with this part. But the rest part of the report also cannot be sustained as the demarcation notice was, I've taken a plea in my data application that no notice of demarcation has been given, ground has been raised. Not to find a paragraph 11, this point has been raised. My case for regulation was not considered. And this report came to be passed. So I'm saying what this report has to be set aside.
Where is the report? 17.
No demarcation in my case.
That is your prayer in the petition? Yes, Mr. Chakravarti.
For my lords, I'll have to respond to this allegation that was carried out in his absence, my lords. It's a factual allegation.
They have been given sufficient opportunity.
I appreciate that, but
Any document to show that they were served with a notice or did not appear despite service?
my lords, then I'll come back tomorrow morning.
Why don't you consider a fresh demarcation in their presence?
Then the entire,
That's the small
report
issue
has-
involved here.
my lords, then.
The entire report has to be set
entire-
aside
entire
because it
report has
was
to be set aside.
not done in their presence.
My lords may then dispose it of, my lords, on those days.
Because the previous page, page 16 also says that only to the extent that the concerned occupants have maintained continuous possession. So that
Well-
part is not in dispute actually, isn't it?
My lords may
So
then,
without going into merits,
my lords,
let the authority demarcate the land afresh in presence of the
my lord,
petitioners.
my lord. That can be.
Heard learned, yes, shall I pass an
My
order?
lord,
Heard learned counsels for the parties. The predecessor in interest of the petitioners in the present writ petitions possessed the plots in question since prior to 1942. Stop. The petitioners claim to be in continuous possession of the said plots till date. Stop. In terms of a scheme laid down by the Ministry of Home Affairs, Government of India on 15th July 2003, the excess land possessed by the pre-1942 settlers will be regularized only to the extent that the concerned occupants and their descendants possess continuously. Stop.
if my,
The scheme proposes a survey to identify the pre-1942 settlers / their descendants and the exact area of excess land in their possession up to 1961. Stop. Paragraph learned counsel for the petitioners.
my lords permits me for I'm sorry, my lords.
Yes, yes.
Page 34, my lords. This
Of
part,
the writ application,
yes, yes, ma'am.
page 34, there is no page 34 to it.
This is this is part of the order passed by the deputy commissioner.
Taken some other price.
The first file has been taken up. They are all identical, I think.
Order dated 21st January 2021.
This is not.
Of,
This one, there is such the recognition.
of this court?
No, my lord, my brother is seeing some other file. Rekha Rajani.
Yes, because orders are being passed in all the files in a combined manner.
It is also young first killing and first killing.
Claim petition, my lords, WP of 2021. My lords has the file of claim petition.
Yes, 105 of 2020.
Yeah, 21 ka there is other set of proceedings pending.
No, there's another prem kishan in WPA 71 of 2021. You're referring to that?
Yes, my lord, this 71 of 2021.
71 of 2021, please. 71 of 2021. Yes,
My lords, in this, if my lords comes to page 34,
34, yes.
here, my lords, it is specifically recorded that there was demarcation was carried out in the presence of all the tenants of the aforesaid landed property. And after demarcation, it was found that she Prem Krishan is a recorded tenant of the land bearing survey number such and such. The said landed properties are lying vacant, but she Prem Kishan has constructed double-storied RCC building in survey number such and such and is an illegal occupation of the following landed property.
The recorded tenants as indicated in the tabulation, the other tenants,
No, that includes the.
not my client. Recorded tenants of the named in the tabulations. They are other persons, adjacent properties.
All the tenants, my lord, it says all the tenants.
Tabulation. Then only the report. Serial number.
And you have recorded that he is in illegal occupation. So this illegal occupation is for regularization, isn't it? This has to be regularized. It is not in dispute that they are in illegal occupation.
My lord,
They are occupying in excess.
my lord.
So that excess occupation needs to be regularized. That is the scheme.
But this suggests that it was demarcation was done in his presence. I think it's the only thing which I. My lord sees. Page 32 onwards.
In presence of all the tenants of the landed property.
It's in, plural law. Those named in the tabulation, their property, contiguous property, they will remain present, but not the pre-petitioner. Nobody
And
says-
the recorded tenants are some other
Other,
people.
yes.
Please see the tabulation below
I
that.
have to see page 29. If you may just read from page 29 onwards. During the pendency of civil divisional application filed by the petitioner, that is Prem Kishan, proceeding of revenue case before this court was in process. During the hearing on 2nd March 2020, parties informed that there is dispossession of eastern side of the land bearing survey number such and such, which needs to be demarcated to know the exact cause of dispossession, and accordingly an order of demarcation was directed, which is to be carried out on 6th March 2020 at 10 AM, headed by Shri Hari Calcutta IS, Assistant Commissioner, along with other officials of Revenue Authority. As per the order dated 2nd March 2020, demarcation was conducted on 6th March 2020 in the presence of all parties in the supervision of Shri Hari Calcutta. And after demarcation, report was submitted, which was found as under. So Shri Prem Kishan, this is the recording in against him, then similarly in against the other petitioners. Then, my lords, the demarcation for page 31 says further reveals that above said recorded tenants, the above said recorded tenants includes Prem Kishan, have constructed buildings over government revenue land bearing survey number such and such, measuring an area of such and such respectively. It was found that the above tenants have not fenced their individually, as such their individual occupation over this survey number could not be measured. However, an area of 6.6200 hectares out of survey number such 103, an area of 0.2200 hectares out of survey number 101 is under occupation of the tenant as mentioned in serial number 1 to 5 above, which includes preemption. After the demarcation, a sketch map was also prepared bearing details of occupation held by the above tenants are categorically shown in the map. The demarcation report was submitted on 9th March 2020 and copy of report was served to the parties. And after supply of copy of report, final hearing was held. On the date fixed, the learned counsel for Prem Kishan has filed an application praying for time to file reply, and accordingly case was adjourned till 20th March 2020. But subsequently, none of the parties have raised any objection to the demarcation report. Though the case was fixed on 2nd March 2020, but the same could not be taken up for hearing due to COVID-19. And after lockdown, the case was fixed on 19th October 2020, but some of the petitioners have not appeared. Accordingly, the case was fixed on 12th November 2020 for final hearing. On 12th November 2020 could not be taken up. And finally, on 7th December 2020, case was taken up for hearing and all the parties were present. Petitioners submitted an application praying for closing the proceedings on the ground that they have filed an application before the Hon'ble High Court. And the administration has filed application for extension on the time of the order dated 13th January 2020. All the parties have agreed that they made their submissions, do not want to make further submissions, and accordingly case is fixed for final order. Having discussed so far, it is observed that various complexity involved in the matter have been addressed too with minute details due to the efforts taken to demarcate the land multiple times so as to depict the current status and passing multiple survey numbers. As per demarcation conducted in the presence of Assistant Commissioner South Andaman on 11 January 2019 with respect to land measuring serial number such and such situated at such and such village, Nayagaon village under Port Blair Tehsil, it reveals that an area of 371 square meters out of survey number 93 is under illegal occupation of Prem Kishan, son of such and such, and due to illegal occupation, following persons have found less area in the recorded land. It is observed that the above finding clearly show that the matter is that of illegal dispossession. From the above demarcation, it further reveals that following persons have occupied the recorded part, wherein serial number such and such while occupying the respective.
So that is on merits.
Yes.
That is on merits.
So in his presence, it was actually the demarcation was carried out. And on that basis, these conclusions have been arrived at.
Yes, and the proceeding was stalled due to a writ petition before this court, I think,
Yes, ma'am.
on prayer of the petitioners, on request of the petitioners.
Yes.
So, Mr. Jaipal, what you can,
Come to paragraph 11
Of?
of the writ application. It's my concrete case before this court. This has not been dealt with by the paragraph 11, page 7. The writ petitioner in the
which
report-
writ petition, the sec,
the first one, Lord. It's the WPA number 105, item number 13,
paragraph, page
Paragraph.
11.
11 and page 7.
Yes. I'll call them.
Sixth line from the top, the writ petitioner herein was not given notice of demarcation even by the revenue officer. As such, all the exercise of demarcation was done in absence of the writ petition, which is capital as the writ petition lost its valuable right to place land as against.
Mr. Jaipal, I think this doesn't really hold water. Because the report says that you have also, you wanted to file an objection also, a hearing was fixed, and then on your request, it was stopped. Application praying for closing the proceedings on the ground that they filed an application before the Honorable High Court. So I can at best grant you liberty to file an objection against the demarcation report and let the authority deal with it.
Or they can file a statutory appeal before the before the Secretary Revenue.
Against the
That is
demarcation?
there.
No, this can't be done.
The order
there
of the
any-
Deputy Commissioner, it is appealable before the Secretary Revenue under Regulation 28.
30 is concerned, it's a report. As against reports, no appeal lay under the local regulation. Let them show any law, my lordship. I can approach as against this report. This report, there has to be a finding.
No,
Lord,
there is
against-
a order.
Page 17, annexure P4. Regulation 28 of the local regulation here. it
In
was-
WP 71, it's an order,
Yes,
but orders have been passed in all the
the
cases.
same order is passed,
Should be, but I do not.
not have been. All these people are mentioned. now. Yes, madam. Same order is annexed also.
At-
30.
At page,
It's my lord, This is the same petitioner, my lord. Same petition has filed two petitions. So, my lord, same
It's the
petition-
same petition.
Yes, it's, but this is 2020 writ, so subsequently has filed, placing that on record. But so far as the other petitioners are concerned, in their case also, they have annexed the same order.
This appears to be a report and not an order. Please come to page 17 of the first writ petition. A report will not be appealable, isn't it?
Regulation 28.
Yes, but subsequent to this, this order has been passed. So now that is the report of this Hari Kalikat IAS. So based on his report, the deputy commissioner has already passed an order.
Please also challenge item number 17.
Yes,
is
so
also-
once the order has been passed and the order was passed after hearing them, this report will merge into the order. They have challenged the order, which they have accepted that
The
position.
scheduled date was fixed for demarcation. I raised objection. Let's go by what the other side says. In my absence, demarcation was done. Let them
The
show.
order is
The-
recording, it's
The
not.
record doesn't say so.
No, I have raised objection. That is recorded. I have raised objection.
You have raised objection against the demarcation
Yes.
done.
So,
So not that because of your absence during demarcation.
but the
You're not happy
demarcation-
with the demarcation report.
But the demarcation was postponed on that day. But on the subsequent date, in my absence, demarcation was done and order came.
The report doesn't say so, sir.
No, just let me see.
So, my lords, the order
There
is
is the provision for appeal against this order.
regulation 28, my lords of the land revenue.
Regulation 20.
28. Yeah. My lord may have regulation 28. My lords will see appeal and appellate authority. And my lord will straight away, my lords have 28(1)(d). If such order is passed by deputy commissioner, whether exercising powers of deputy commissioner or settlement officer, then the appeal will lie to the chief commissioner, which is the lieutenant governor. So there is a appeal available to the lieutenant governor.
Regulation 20.
8,
28.
my lord,
Yes.
chapter 4, regulation 28(1)(d). So, my lords, the appeal will lie to the lieutenant governor. My lords, they have a remedy of appeal.
Yes, Mr. Japan.
May I consent if, number 7?
This is an appellate order,
No, no, no.
appealable order.
Let me see, because I am carrying 14 to 13. In 13, no decision has been taken.
13 is a report,
No, no,
and I think it's a combined decision for all the petitioners.
they have not said so, no, you know. it may be-
Will you come back with a
Third-
short
No,
report?
yes,
No, my lords, my submission is this order with 13 was a report.
Yes.
On the basis of the report, the deputy commissioner has passed an order which records the fact of this demarcation having been carried out and the parties having been heard. Now the report has merged with the order which is passed by the
No,
deputy
Should be,
commissioner.
the
should be.
report dated may kindly be seen at page 17 now. Report page 17 may kindly be seen once again, Lord.
Yes,
Lord,
yes,
kindly see the reference number at the top to date.
yes.
Nowhere in the order which they now rely deals with this report. It's report under reference number file at the top, page 17 in item number 13, Lord. At the top.
Yes.
F number 68/LC/2018/1679 dated 3rd March 2020. Not the order which they say that it has been passed, nowhere discussed with this report. It may happen so, my lordship, they have prepared the report, they have relied it, they passed the order. It may be a situation. But this report, because this is the genesis of the matter. They have taken this, they simply took a decision based on this report, giving a logical conclusion to the proceeding. But this report, nowhere they have dealt with in the order. If I go by what they say, that the order has been, the report is culminated in passing an order, then there has to be reliance to this report.
This order was passed on the basis of an order of this court, passed on 13 January 2020. And it is the report which is under challenge and not the order.
The order has been challenged in that serial.
So that's not to be taken up independently.
No,
So
no, but point is, my laws may just see, this is 9th March 2020, page 18. The date of signature is 9th March 2020. And
Yes,
if my laws compares it with the deputy commissioner's order, that
yes,
is the same thing. It says the demarcation report was submitted on 9th March 2020.
but
again,
not in
concerns-
terms, not in terms of the order, the report.
No, the report was submitted to the deputy commissioner. The deputy commissioner has now passed an order. If the report has merged into the order, so.
That's why I say, will you come back with a short report
My lord.
indicating that this report has culminated into an order?
My laws may then.
Because if it is an order, the orders are
Yes, we
appealable.
understand. My lord.
Then my laws may have it on
Friday,
Monday, my laws may have it. Only because I need to get it,
yes, yes. A very
Okay.
small point that the reports have culminated in the order
my lord.
in all these cases,
Yes, ma'am.
because they are being taken up analogously.
Yes.
Heard learned counsels for the parties. Paragraph. Let the matter appear on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16
Fine.
Monday. These matters, huh? Let them retain its position. huh?
No, I'm for the respondent, even during the last subject, the other side was very eager to get the matter appeal disposed of. I'm ready with the matter. It can be taken.
It was the appellant. I'm suffering from cough. Monday it may be fixed. I may not be in a position to do tomorrow. Monday it may be.
Come
I'm
up on
ready.
Tuesday in that case.
Lord.
On prayer of the appellants, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17.
This is on remand, Lord, persons are passed certain orders. Good. I need implementation, my writ was dismissed. A mandamus appeal was taken out, the matter has been remanded. Their authority have to be with me. They cannot resist my. writ
Time for the
application.
private respondent. I pray not today. Because there are certain developments in between. The order which is sought to be implemented is under challenge.
No stay has been granted. These
Maybe-
things have been thrashed out. These points have been thrashed out before the division that.
No, this is
These
the
have been thrashed out.
So will you come back on Friday?
Friday.
On prayer of the private respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th.
Item 22, the rule was 9 even this matter is on remand.
Yes. You want to, reply is not filed.
It has been filed.
Reply has not been.
Please, order copy.
Copy of reply, my lords, have been,
Not filed.
It has been filed, my lord.
I don't know if it's on
The
record.
adverse side says that copy has not been given. I'm giving another copy.
Is it on record? Reply nahi hai na record.
It's not on record.
It has been filed, my lord, in the registry.
Position was there.
Short matter?
Very short.
Which is why the learned
The
single judge,
report in the first round.
reply is not on record.
Will you come back on Friday?
My lord,
Friday?
my lord.
None.
By consent of the parties, let the matter appear under the same heading on 13th.
You come. Maybe.
Second 23, SIG 10 of 2020.
No, this is has appears for the respondent and for the appellant.
I do not find her.
Just not today.
Come back next week.
No.
All matters are being made for today. None appears for the respondents. Paragraph, let the matter appear under the same heading on 19th.
Second 24, WK 149 of 2020.
24, I appear for the respondent, my lord.
Petition, the petitioner. It's again Ms. Nag.
Yes, ma'am.
None appears for the petitioner. Paragraph, let the matter appear under the same heading on 19th.
Obliged, my lord.
25, SIG 3 of 2021 is the 7 of 2020.
Lord, I am appearing for the respondent.
Petitioner,
Mr. Hon'ble, that is appearing, my lord. It's not.
none appears for the petitioner. Let the matter appear under the same heading on 19th.
Item 27, SAT 5 of 2021.
27. No one. None appears for the parties. Let the matter appear under the same heading on 19th.
Item 28, WK 5 of 2022.
I am appearing for the respondent, madam.
Petitioner,
Mr. Haldar's name is showing.
yes. Let me see. There is no one.
No, madam.
After 2 p.m. it's difficult.
2 p.m., madam.
The councils are busy in the district court. I
Yes,
think.
madam. They have to go to the.
But then how do we dispose of matters? How do we deal with matters after 2 p.m.? Difficult. Reply has not been filed as yet. Have you received a copy of the reply?
No, madam.
None appears for the petitioner. Paragraph, let the matter appear under the same heading on 19th.
Item 29, WK 44 of 2020.
This, my lord, Mr. Rajendra Singh, my lord, is not well. I don't think so.
So next circuit.
No, some of his matters, prayer was made in the morning, adjourned for Friday.
Friday.
My lord.
None appears for the petitioner. Let the matter appear under the same heading on, so let it appear on Friday.
My lord.
13.
Item 30, WK 46 of 2022.
This, my lord, Miss Nag appears for the petition.
None appears for the petitioner. Let the matter appear under the same heading on 18th.
Item 31, WK 70.
This can be disposed of. There are bunches of matter which are taken out. One is left. That's the one. Those matters have been disposed of. Item number 31.
Affidavits are complete.
No, in other matters, they have not used opposition. It has been disposed.
There was a direction in this matter. I think. Yes, they can use an affidavit in opposition. in this matter.
I seek extension of time, ma'am.
You will use an affidavit.
My lord.
Lord, may I say one thing? My brother was there in those matters. Same directions, argument was done in.
Yes.
Let it be not today, my lord.
My lord. There are orders from the division bench.
Why don't you provide him with the orders so that he can
Yes,
go through
yes.
part of the writ application. It's a part of the writ.
the earlier
Yes,
orders?
yes, every orders are in part of the writ. They are having the copy of the writ. Not defined by Justice Anindam Sinha and Justice Rashekar Manga. Order dated 2nd September 2019
At page,
at page 47. Page 47. They have to consider my grievance in the light of this because they are identically
What is the notification that you asked for?
It's under section 48, releasing the property from acquisition. My property falls.
It was used for a different purpose,
Yes, no, for the use for dumping this soil excavated for airstrip.
but they've used it for a different
But they have
purpose.
not used it. They have given a submission before the division bench that we have not used it. So the court said you take an identical, you issue an identical notification. And in so far as those cases are concerned, they have returned the compensation with interest in the administrative office. And on the round of parity of visiting ownership, I am similarly circumstanced. And even during the last circuits, there are two matters, the same line, those two matters were disposed of. It's the last one which is left out. I can place those orders also to my brother.
You need to take instructions in on this,
My lord, let it be
or shall I
fixed.
pass the same order?
My lord may pass the same.
I'll pass the same order. The writ petitioner seeks parity with writ petitioners of with similarly situated writ petitioners in earlier appeals being MA numbers 28 of 2019, 29 of 2019, 30 of 2019, and 31 of 2019. Stop. Paragraph. The petitioner contends that he was the recorded owner of the lot in question, which was acquired by the respondent authorities under the Land Acquisition Act 1894 for the purpose of dumping excess soil due to extension of the airport at Port Blair. Stop. Award was granted to the petitioner by the authority. Stop. The administration did not utilize the land for the purpose for which it was acquired. Stop. The petitioner seeks issuance of notification by the authority under section 48 of the Act of 1894 for return of the land in favor of the petitioner. Stop. In the paragraph, in the earlier appeals, as referred to above, comma, according an honorable division bench of this court, comma, by an order passed on September 2, 2019, comma, directed the administration to consider issuance of notification under section 48 within bracket 1 of the Act of 1894 and afford an opportunity of hearing to the appellant in passing the notification, comma, if required. Stop. Learned counsels for the paragraph, learned counsels for the parties submit that a similar order be passed in the present writ petition also. Paragraph in view of the above. The notification earlier issued by the authority on 20th November 2000 is required to be set aside. It required to be set out. Page 49 of the writ petition from whereas till with immediate effect. Paragraph in view of the above, comma, the writ petition is disposed of. Directing the concerned authority, comma, being respondent number. Who should deal with it?
It's collector.
The collector?
Collector land.
Being the third respondent here in comma, to consider issuance of a similar notification in favor of the appellant within 4 weeks.
Within 8 weeks, my lord.
Why?
A notification that they have to claim some of this.
6 weeks.
My lord,
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, if required, comma, in accordance with law. Paragraph, in the event the authority takes a decision in the negative, comma, a reasoned order should be passed demonstrating the reasons therefore.
my lord.
Disposed of? Disposed of.
Oblige, my lord.
It's the petitioner here, WPA, not AP.
My lord, I am appearing for the petitioner, my lord.
Yes. Respondent?
My lord.
Yes.
My lord.
Yes.
My lord, here the petitioners, after a selection process, were engaged on daily wages basis under the respondent authorities way back in the year 1993 to 1996. There are several petitioners. Now, my lord, subsequently in the year 2000, they were given the minimum wages also, 1/30th, they were given. My lord, they were working for years together, their service not being regularized. My lord, subsequently, the Andaman and Nicobar administration has mooted a proposal before the ministry for regularization of their service by creating a supernumerary post. My lord, that was not done, though several correspondence were taken up between the ministry and the administration. Ultimately, we took out a writ petition before this Hon'ble court. This writ court passed an order directing them either you create supernumerary post or you reject it by assigning reason. Now, my lord, after that, my lord, and a time was postulated within that period it ought to be done. My lord, on the basis of that, ultimately, my lord, the ministry accorded approval for creation of supernumerary post. Now, my lord, on the basis of that, supernumerary posts were created. And my lord, an order was passed. The effect of the order was given prospective, my lord, by the administration. I am on that it ought to be retrospective effect. Now, my lord, on this course, same administration, it's a clear case of discrimination, my lord. When earlier the Home Guards approached this court First, they approached the tribunal. Ultimately, the matter went up to Supreme Court. And thereafter, supernumerary post was created. More than 300 posts were created, my lord. And the approval which has been given by the ministry in that case, in my case, is apt, my lord. There is no difference at all. In their case, my lord, the administration regularized their service. These 300 and odd people from the date of initial appointment. And here only 10 or 20 persons are there. They were given this benefit from prospective effect. I am challenging only that part of the order. My lord, I will show first, my lords, the order passed by this court in our case, my lord. Kindly come to my lord, page number 56.
Yes.
Relevant would be, my lord, this is an order dated 27th of August 2019, my lord. Relevant would be, my lord, page 57, my lord, second paragraph.
Yes.
On perusal of correspondence enclosed in the report, it appears the administration maintained throughout that some of the 32 workmen were engaged through employment exchange other than daily wages basis and thereafter casual basis. They have since completed 20 years of service, as their service are essential to Directorate of Information, Publicity and Tourism to meet functional requirement of the administration. The government of India, in following up with several queries, have indicated that it is not a fit case for creation of post. In circumstances aforesaid, the respondent number 1 is directed to make its decision on the issue known within 4 weeks from the date of this. It is expected that the decision, if it is in negative, will carry reason in support of it. Now, my lord, after this, at page 58 is the approval concurrence of the ministry, my lord.
58.
My lord.
Yes.
This is of 21st of November 2019, my lord. It says, my lord, this is being communicated in compliance of the Honorable High Court order dated so-and-so, passing WT number so-and-so. The proposal of the administration dated 16 July 2015, forwarded by the Home Ministry to the Ministry of Tourism on 14 September 2019, was considered and consultation were made with the Department of so-and-so. My lord, para 3 is relevant. The undersigned is directed to convey the approval of the competent authority for creation of 32 supervisory posts for regularization of workmen working in Andaman and Nicobar administration subject to the conditions in para 4 of the Department of Expenditure dated so-and-so, my lord. Thereafter, my lord, this was created, my lord, and approval was granted. Now, my lord, kindly come to page 60. This is the Ministry of Home Affairs, my lord. This was with regard to Ministry of Tourism, which I have read, my lord. Now, Ministry of Home Affairs. It says, my lord, this is 29th of November 2019. I am directed to say that in compliance to the direction of the Honorable Court, dated so-and-so, filed by so-and-so, has considered the proposal on so-and-so for creation of 32 supernumerary posts for regularization of workmen in the directorate of so-and-so, in consultation with so-and-so, has conveyed the approval of the competent authority with letter dated 21st November 2019, which I have read, my lord. It is requested that necessary action for implementation of the order so-and-so issued by the Ministry of Tourism may be taken on priority to avoid any further legal complication in the matter. My lord, this was addressed to the Chief Secretary of this island, my lord. Now, my lord, kindly come to the order in tune, my lord. This is of 13th March 2020 issued by the Andaman Nicobar administration. It says the Director ITMP is pleased to appoint. My lord, the nomenclature itself is wrong. It is not appoint, it is regularization, my lord. Appoint the following 29%. My lord, 3 persons died, my lord. Supernumerary posts never pass over, my lord. Since they died, therefore no right to the family, my lord. That's why 49 posts. Supernumerary post of workmen with effect from 21st of November 2019. I am affected by this part of the order, my lord. In the level of so-and-so, so-and-so, so-and-so. Now, my lord, all the benefits which are there that has been given, my lord, but the date of effect is from 21st of November 2019, my lord. Only this part of the order I have challenged, my lord. Now, my lord, kindly come to, and my lord, we have accepted this order at page 63 onwards. All of us.
What is the reason behind this?
No reason, my lord.
Explanation?
No, my lord. My lord, I will give you.
Because the order was on 13th March 2020. Order was passed on 13th March.
My lord.
So this is really not prospective. It's little earlier.
No, my lord. This is on the basis of approval. That approval which I have read
On the date of approval.
approval, my lord. Now, my lord, I will show similar approval by the ministry wherein they have given from the date of initial appointment. I will just place that. Before that, my lord, kindly come to our duty report, my lord. I will show one of it at page 63, my lord. On the basis of this order, we have reported, accepted the letter for appointment. And my lord will find, I say that I hereby accept so and so as per the terms and condition, without prejudice to my right to claim past service and all consequential benefits, my lord. All of them has written, accepted it without prejudice to their right, my lord. Now, my lord, similarly, this whole when the service was not recognized for years to one after another, several writ petitions were filed. Thereafter, this division bench passed an order, presided by Hon'ble Justice Jyotirmay Bhattacharya. Ultimately, the matter went up to the Supreme Court, and I have annexed all these orders, my lord. Supreme Court passed an order, my lord. Ultimately, if my lord comes to the approval of the ministry, my lord, at page 111.
Yes.
Ministry, my lord, this is 13 September 2019, my lord. 2009, I'm sorry, my lord. 2009, my lord, we'll get it at the bottom of the said letter, my lord. It says, I am directed to refer to the letter so and so on the subject cited and to convey the approval of the competent authority for creation of 3 so and so posts for the purpose of regularization of in accordance with the judgment of so and so. Now, my lord will find here also, my lord, the approval was there. They have accorded their approval. If my lord sees the language of the approval in the case of the petitioner, and here there is no difference at all in terms of the judgment of the Supreme Court, my lord. Now, my lord, kindly come to their order at page 112.
Yes.
My lord will find, it says in exercise of the power so and so, the Lieutenant Governor, so and so, similarly page 109, from the respective initial appointment for implementation of the judgment dated so and so passed by the Honorable High Court and in pursuance to the judgment of the Supreme Court. Now, this was the sanction accorded and by the administration, and thereafter 130, they got the benefit. If my lord comes to page 113. 8th December 2009 is the order. It is issued by the Home Guard, Office of the Commandant, my lord.
From the date of initial.
Initial, you are recognized the post of so and so from the date of their respective initial deployment in Home Guard. There were 300 and odd person, my lord. They got all the benefit from the date of their initial appointment. So I am seeking parity. I am under the same administration. Why this discrimination, my lord, when we are similarly circumstances? My lord, otherwise, my lord, the service which you have rendered from 1993 onwards, my lord, the entire service go. We have served for more than 20 years, my lord. At the age of 45, 48, we have been given this supernumerary post, my lord. Kindly consider this aspect, my lord.
Yes.
My lords, firstly, my lords, at the very outset, my lords, regularization, my lords, now there are several judgments, my lords. Regularization can only be granted if there is a policy for regularization. Now, my lords, recently, Mr. Kumar is also aware, my lords, in respect to all the DRMs working on the islands, my lords, under the aegis of the division bench of this court and then Supreme Court, my lords, time has been granted to the administration to come up with a comprehensive scheme for regularization by 30th of November. Plus that order, my lords, unfortunately, I'm not having it today, my lords. That order of the Supreme Court also records that an affidavit has been filed by the administration, and it is now being discussed at the level of DOPT, and final approval is awaited, and that process has to be finished by 30th of November. So, my lords, my first submission will be that, my lords, that applies to DRMs, day-rated Mazdoors, across all departments, and this is admittedly a department in the administration. And that scheme will have certain eligibility criteria, etc., which will be applied across the board.
That will supersede.
According to me, my lords, it will supersede, because, my lords, here today they are also working as DRMs in the administration, or if they are working as casual workers, they are now working as supernumerary posts. But, my lords, the scheme for regularization will take into account all the persons who are working. So, my lords, perhaps, my lords, according to me, my lords,
You want to wait till the
it
decision?
should let the scheme come out, because my learned friends' concerns may be met in the scheme itself, and a separate treatment cannot be, my lords, therefore, my lord, my submission
waited
will
on
let it
that.
come in December.
That has got nothing to do with this. I am that matter. That is a matter entirely different with regard to the short appearance, not with, I am holding a supernumerary post.
No, I will.
I am seeking only retrospective. I don't know how the learned is looking such submission. My lord.
Order, let it come.
I appear as my learned friend knows that. I am for the petition.
Learned counsel wants to wait, you have waited for such a long time.
My lord, I will place that. That has got nothing to do with the instant case. That was with regard to an affair of the daily rated employee. I am not a daily rated employee. I am holding a post.
No, I just.
My lord, that has got
I will place that.
let him place it, my lord. I will also place tomorrow, my lord.
Let it come tomorrow, I'll place the odds.
Absolutely not, my lord.
Day after.
Day after.
My lord.
Or learned counsels for the parties. Learned counsel for the learned parties, then learned counsel for the respondents seeks to produce an order.
Yes, ma'am. Produce documents in connection with scheme for regularization or minus with
Seeks
order.
to produce documents with regard to the scheme for regularization of employees in the departments of the administration in the islands. Paragraph. You have to come back with an affidavit in that case. A
So,
supplementary.
I'll just place the order, my lords. I'll just show the order. So court order.
Let the matter appear under the same heading on 13th. Day after. What is the difference? You-
There are several matters, my lord, already.
Please put it fairly at the top.
Nine.
My lord, in this matter, my children will be ratified during the government, and he is not very, like the matter will be fixed before the next session.
Unless I'm appearing for the respondent. State respondent.
It is submitted on behalf of the petitioner that learned counsel for the petitioner is unwell and may not be able to appear in this circuit. Paragraph, let the the matter be placed before the next available circuit bench. Next.
Appearing for the petitioner, I'm saying for next circuit. Harry is not in station.
Paragraph on prayer of the petitioners, the matter be placed before the next available circuit bench.
I am appearing for the respondent.
It's not today, madam. Not today, madam.
There is the petitioner. Why not today then?
I have to seek instructions from the petitioner. It's not in station.
Will you come back next week? Yes. On prayer of the petitioner, the matter is adjourned. Paragraph, you'll be there.
Yes,
till
yes,
next-
I'm available.
Let the matter appear under the same hearing on 18th.
Man.
Section 5 application. I served notice upon the respondent, I file affidavit service, nobody is appearing. So my application under section 5 is to be heard in your lordship. There is a delay of 115 days. And during that period, the Honorable Supreme Court also from 15th March 2022 till 28th February 2022 relaxed that period. But thereafter also 115 days delay. Because if I mentioned in paragraph number,
You filed your affidavit of service?
lordship.
Yes. There is no affidavit on service on record.
I filed it on the
No, I don't think so.
July month, I filed it. Copy I'm having.
No, there is no reflection in the order sheet. There was a direction, but then it's not filed.
Affidavit, complete service.
Please come back with the affidavit.
It is to be searched in the file, which is. It's still file here.
Friday,
Right.
since affidavit of service showing service upon the respondent is not filed, comma, let the matter stand over till 13th. No one?
I appear for respondent, my lord.
None appears for the petitioner. Let the matter appear under the same heading on 18.
Obliged, my lord.
Next.
Item 38, WPS 56 of 2022.
In this case, my lord, we request some time to file reply, my lord.
Yes,
In this case, item 38, my lord. My senior is appearing on behalf of the writ petitioner, my lord.
yes.
We request some time to file reply, my lord.
I am appearing for the respondent.
Reply not filed, has it?
Okay.
Learned counsel for the petitioner seeks extension of time to use the affidavit in reply. Paragraph, next circuit. Within
18
one,
may be fixed.
you file within 1 week?
Let me give a chance, my lord.
Yes,
Give a chance.
you have missed the chance, sir. The chance was given to you. How long will you take to file your affidavit in reply? 1 week? Still it goes to the next circuit. Affidavit in reply be submitted within 1 week from date. Paragraph, the matter be placed before the next available circuit bench.
I'm therefore. The intervention of this court twice, the authorities have passed order. That has not been implemented, for which this application has been taken.
Don't have a copy of the copy.
You don't have a copy?
No, the problem with the administration is they keep on changing lawyers. Mr. Shiva used to appear, I have given 2 sets of.
Then if Mr. Balan is appearing, then I'm some confusion. Litigation must have created a confusion. Please. Then if he is appearing, then I'm.
You want a copy? I will give.
No, no, you will appear.
Why is he was served with Mr. Shiva?
No, no, if the litigation department makes a mistake.
You received a copy?
He is here,
My lord.
Mr. Balan is appearing.
Opposition has been filed.
Yes, I find an opposition also in this matter.
Respondent have reduced my record.
Have you served the private respondent? That's over?
We'll check once again. No, file the application. It has been done. That's right.
Where is the order dated 17th December?
It's at page 44. Last annexure. Before the Bakara. Passed by the. The Tahsildar held that my property has been unlawfully possessed by the private respondent. Then he has to edit it.
You've asked for implementation of this order.
Yes.
So why affidavit in opposition?
My lord, this actually this writ was not maintainable because
My
regarding
brother makes a serious type submission, Lord. Their own order I am seeking implementation. How could he say
no
that?
that
It's
scheme,
not maintainable
Which matter?
stereotype argument.
Not delivered upon the private. It's not delivered upon the private respondent, I'm afraid. It's item dispatched.
In such a case, no need to come.
Will you get hold of the subsequent track report
Yeah. Take myself to class with this, whether it has in fact with certain.
Friday?
No.
I was wondering why this opposition has been filed. It's your order which needs implementation.
This opposition has been filed.
Why?
I am saying
Routine.
that there are two writ petitions of the same petitioner.
Those things, those who need person dispose of orders of. One by.
The innocuous prayer is for implementation of your own order, sir.
There is also same.
Can you come back tomorrow? Mr. Jaipal, can you come back tomorrow? Only thing I need to see service upon the private respondent.
My lord. I will check it.
Not today, same position, no? Let it be little bit at the top, yes, just agree with. It's a very short. one.
Item 40, Lord, I am appearing for. Mr. Karu for the, just not to the, just that.
Very well, not today.
Some urgency because.
Mr. Chakraborty, where is he? We're just here. Mr. Chakraborty, you're ready?
Yes. No, what has happened? The commissioner was inducted in a property as a tenant. The respondents, that's private respondents are landlord. But during the subsistence of tenancy, they have decided to convey the land to the building, portion of the building where I'm running a restaurant come bar.
You are a tenant.
I'm a tenant, initially I was a tenant, but during the operation of tenancy period, they decided to convey it to me, an agreement for sale was entered into. Since sale could not be executed, I went pending, there is some entry information done. But the portion of the food land where I'm running the bar license, and license is required to be obtained from the excise department. Initially, it was granted time to time, it was extended. Now that has been rejected by order in June at page 61. Dated 30th July, it's a communication.
Again, have you served the private respondents?
They are appearing on.
Who is appearing for the private?
Some of the respondent I represent.
Some Mr. Mohammed Tabriz, he has already entered into appearance, order sheet would show.
But he is not appearing this circuit because of his wife is unwell. He has to travel to the mainland.
So 2020, I understand lawyers posting difficulty, those things I am conscious, you know, I also take time on these ground, but you know, my client without a license, I could not run the business.
I understand, but then since he is not represented, I think we should not take up the matter, isn't it? Next circuit,
But may I say one, thing? Let it come on 2018. Let's take chance. If he comes, I would request him to come. If not, I will not bother this cooking. I will not even press the application during this.
very well. 18th, on whose prayer? By consent? Yes, by consent of the parties, the parties, comma, let the matter appear under the same heading on 18th.
Item 42,
Not today. Not today. Not today. Not today. Please keep calling the matters. If both sides are there, I'll take up.
I am appearing in 46.
In 46,
For the respondent, in 47, I am for the.
Mr. Balan is for the,
Yes, ma'am.
Did you
Mr.
raise
Balan's name is. okay.
is he there? No, not today.
I am appearing, my lord. For the petition.
Ms. Nargis, not today.
49. I am appearing. my lord.
Yes, 49, 50 and 51.
Yes,
I used to appear at one point of time. My name is strongly because my name may be expansion.
you are not appearing in these matters.
Yes, I'm
I
appearing.
am appearing for the petitioner in 49.
Respondents in all three matters?
Whereas I'll have to ascertain with.
Let me
Mr.
call one by one. 49, are we ready? With
No, no.
49,
I think it is with Mr. Balan, ma'am. I'll have to check, ma'am.
Sir is appearing.
shall I make it only not today? 50, not today.
No.
51, I am appearing, my lord. Lord, this required hearing, my lord, because what happened, my lord, there was some of the workers, there are numerous workers who have been disengaged. Subsequently, my lord, a conciliation proceeding was initiated. In the conciliation proceeding, my lord, a statutory settlement was arrived between the parties. My lord knows very well statutory settlement is binding upon the parties, my lord. Despite of that, my lord, they did not comply. I took out a writ petition before this Hon'ble court, and Honorable Justice Basag has passed an order whereby directing them to take into consideration all the documents and pass an order. My lord, they thereafter pass an order in violation to the statutory settlement and without giving effect to the statutory settlement, my lord.
Sir,
Sir, my lord, Mr.
because here also Mr. Jaipal's name is recorded.
Wrongly recorded.
My lord, this required hearing, my lord, because my clients are facing difficulties, my lord.
Why don't you inform learned counsel and come back? I'll just make it not today.
My lord, I don't know who is appearing, my lord. There are,
The department may help you.
my lord.
Someone else has been appointed.
Last, Mr. Chakravarti appeared in the last occasion.
In this matter,
Yes,
I don't have instructions.
but they
I think Mr. Balan has-
thereafter they say no instructions. Very difficult, my lord. My lord, I'll accept your matter, my lord.
This is the-
please, please.
I will ascertain.
I'll just
which
make it not
department
today.
matter.
I'll just make it not today.
Electricity, my lord, I'll make.
Next,
Item 52, the book 174 of 2022.
52, my lord, I am appearing for the writ petitioner. I have filed a CAN application, my lord. It is it's appearing for first time, my lord. My lord, what happened, my lord? A tender was floated, my lord. In absolute violation of all the laws which are governing the affairs of tender. This court passed after issuance of letter of intent to award. My lord, this court passed an interim order saying that not to pursue further with the said tender process. This was issued on 1st of July 2022, my lord. Now, my lord, in terms of the tender document and the letter of intent to award, my lord, security clearance, it is with regard to ground handling in airport, my lord. Security clearance is to be obtained from the Bureau of Civil Aviation within 60 days, my lord. That has not been done. Now, my lord, this interim order was in existence, my lord, on 14th of July 2023. Security clearance was given by the Bureau of Civil Aviation, despite of the fact there is an interim order, despite of the fact they are duly represented by a learned counsel, despite of the fact, my lord, that cannot be given in terms of the tender document and the letter of intent to award. So I have filed this CAN application for setting aside that order whereby security clearance was accorded to the private respondent.
Lordship, I have not been served with the copy.
Yes, I am served. I did not able to get my learned friend. I have served all other
I
respondents.
also filed my affidavit in opposition. So far, no reply has
No,
been
no,
received.
my learned friend is not aware that I have been given 2 weeks time. Only 1 week was lapsed, my lord. I will file opposition.
So 2 weeks already lapsed, I believe.
I am appealing for 7 and 8.
Lord, today we have been served with the opposition. We will use our.
Lordship, there is an
You
extreme
served-
urgency in
you've
the
been served
matter.
with a copy of the CAN application today.
Yes, today.
I've been served just now. There is an extreme urgency in the matter, your lordship, because tender has already been allotted and your lordship knows that without the functioning of all those authorities, the ground staff.
My client is functioning, my lord, all along from
He-
several years. And moreover, my lord, this interim order was passed on 1st July 2022. My learned friend chose to file the affidavit in opposition only last week. After a year, now they are saying there is an extreme urgency.
There is an.
Kindly see, my lord.
Because the
Yeah,
international
tender.
airport has been now.
First, my application is to be heard out, my lord. So far as the cancellation of,
Tomorrow, your lordship,
There is affidavit in opposition will be filed within a period of 2 weeks from date.
2 weeks.
That was 27th September.
my lord.
So we've crossed that.
No, you
My lord, I will be filing by tomorrow, by Monday, my lord.
so
Affidavit.
this has to be
reply.
listed on Monday, your lordship, on top of the list.
Can't be
My lord,
listed.
my learned friend did not file affidavit for my lord. Can you see the order?
Circuit at all.
One fine day when he comes.
Replies.
Yes.
You are appearing for?
I am appearing for respondent of 5 and 6. Today I
Have
have
you
been-
used your opposition in this matter?
I have to use, today only I received the copy of the.
Scan
can.
application he's talking about.
Yes, yes. So the can has to be disposed of first.
Yes. So can it be done on Monday, your
Affidavits are
lordship?
not come, no, next circuit.
Can application we can dispose of
My
here.
lord, so far as.
Affidavits are called, have already.
So far as the informer is concerned, my lord, we have filed a vacating new application, that is on record. So far as that can application and the vacating application, that can be disposed of.
In disposing of the vacating application, the entire writ petition has to be considered. You must understand. Yes,
My
because
lord, next-
affidavits are not complete, come
next-
back next circuit.
My lord,
Lordship,
next week, my lord,
next-
I am the
No, no.
private respondent.
He is the
I am
ultimate
I am
sufferer
the
here.
successful citizen.
Since affidavits are
No,
not
you look to the.
complete as yet, comma, the matter will be placed before the next available circuit bench.
Lordship,
You should have been ready with your affidavits, isn't it? Taken up the matter.
I have already filed, the other side was required to file their reply. At least we can take a chance on Monday, your lordship.
There are several matters, it will be difficult.
Let him file the affidavit at
I
least.
wanted to do it this week, because then we get some time to continue, isn't it?
If it is on Monday, my
I
elder
don't
brother
think-
can give me a copy of it, then we
My
can.
lord, I am the successful bidder. The security
I
clearance has been
understand, sir.
granted to.
Waited for such long, please wait for a little more time.
My lord, next week it can.
No, no. Next,
I am there for the petition.
respondents,
I pay for the respondent.
yes,
Private respondent cannot refuse to accept the envelope.
so that's
But
service.
the prayer is innocuous. It would not prejudice any order passed.
Please file the refusal,
I'll file by way of an affidavit.
yes,
Lord,
in course of this day,
in course of tomorrow, Lord. May not be
so not today.
Not today.
Oblige, my lord.
The proceeding is pending. Before the Russell.
54,
54.
My lord, in this matter, also my senior Mr. Rakesh Pal Roman is appearing for the respondent when the matter may be before the
That
next.
needs to be concluded within time span.
he says next circuit.
Yes, I'm appearing for the revenue.
You are appearing for the private respondent?
No, no, state.
She is appearing for
Yes, yes, my lord. The
private respondent?
Personal ground,
She's asking for the next circuit,
personal ground, okay.
yes. On prayer of the private respondent, the matter be placed before the next available circuit bench.
Obliged.
So it's 2:45, my lord. Lunch hour.
You want me to stop? You are hungry?
Yes.
Shall I come back? Will you be ready?
If Mr. Chakravarti is available, definitely we can do some matter on the second.
I'm available, but my lords.
You want to come back tomorrow again?
As your lordship.
Tomorrow, man.